All right, we're on record at the BRC this morning. Go ahead and knock out these 33-day motions. I have Barquinas 2021 CF 1632 AO.
Taylor May on behalf of the Office of the State Attorney.
I'm sorry, and Ms. George, put your name on the record.
Letitia George on behalf of the Office of the Public Defender.
For Mr. Barcinas, it was filed yesterday, Your Honor.
I was denied, and I have Ms. Davis here from Pretrial Release Services.
Who's Garcia?
That was Gabriel Barcinas.
All right, I have Daniel 2021 CF 1904 AO.
Notice of non-filing, Your Honor.
Granted. I have another Daniel 2021 CF 1905 AO.
Notice of non-filing.
Granted. I have Ellis 2021 CF 193 AO.
Notice of non-filing.
Granted. I have 2021 MM 178171 AO. Oh, sorry. 2020 MM 71 AO. Apologize.
For Mr. Hendricks?
Yes, sir.
No information was filed.
All right, granted. I have Karen 2021 CF 1853 AO.
It was filed yesterday, Your Honor.
Denied. I have Status 2021 MM 1059 AO.
Notice of non-filing.
Right, granted. Start this morning with an arraignment. Good morning, ma'am. Can you tell me your name? Can you tell me your name?
Angela Talbert.
Ms. Talbert, you're here for arraignment this morning in 2021 MM 116 AW on charge of trespass on property other than a structure or conveyance. That is a first-degree misdemeanor. It's punishable by 1 year in the county jail and a $1,000 fine. You're represented by the Public Defender's Office. Is there an offer she's willing to accept this morning?
No, Your Honor. We're going to enter a plea of not guilty.
All right. All right, ma'am, I'll accept your plea of not guilty. We'll set you for Division 62.
Division 62 pretrial conference, April 12th at 9 a.m. and 9B.
Yes, ma'am. Press what?
I guess so.
James Stanley.
Good morning, Judge.
Good morning. I think it's somebody to turn my TVs on. Here we got one coming on. Hello. Good morning.
Hello, good morning. This is for sign language, correct?
Yes, ma'am. Have you been sworn in this morning?
I have not, no.
Could you raise your right hand to be sworn in? You solemnly swear you'll translate from English to American Sign Language, from American Sign Language to English to the best of your ability, so help you God?
I do. Julie Balassa, nationally certified interpreter.
This is hard. Can somebody turn my TV on down here by any chance? Corrections? Can somebody turn my TV on down here so I don't have to, like, somebody break my neck here?
Your Honor, is it possible to bring the defendant closer? He's too small on my screen.
Yep, we're going to do that in a second. That's what I'm trying to.
Oh, good, good, good. Thank you. And the mask off.
Yep. So you need the mask off?
Yes, American Sign Language, some of the grammar is on the face.
Okay. Right. I guess he can remove his mask while he's speaking with the interpreter. And he can see you better. here too as well.
Oh, good.
Where you are.
Thank you, Judge.
There you go. Yes, please. All right. Look at her. Look at her. There you go.
Thank you, sir. That's all we have.
He can't sign. So I guess we have a sign language interpreter, but he doesn't use. Yeah. I guess he doesn't sign.
Oh, darn.
Okay. Well, because he started speaking, and his English didn't denote to me that he had a deficiency, maybe later in life, maybe of hearing the English.
Oh, he may be late deafened, right? He may be late deafened.
So
In that case, maybe writing would help.
yeah. All right.
Sorry about that.
No problem. Well, thank you. Have a great day.
You too, Judge. Thank you.
All right. Is it too loud? Can you hear me now? Mr. Stanley?
That's better.
All right. Can you hear me, sir?
No.
Can you hear me? Can you hear me? All right. All right, what I'm going to do, because I don't have a
You can
way
hear
to
now?
communicate with Mr. Stanley, other than maybe possibly in writing. He doesn't use the American Sign Language.
Loud.
So I'm going to appoint a public defender to represent Mr. Stanley in 2020 CT 527AW. I'm going to, of course, going to waive his initial appearance as this is a procedural hearing. His bond set at $1,000 for a failure to appear warrant. And he could bond out if he can. All that will be provided to him in writing.
Mr. Allen, you're before the court at this time for an arraignment on an alleged violation of probation.
Thank you, sir. Have a great day.
This has been appointed to represent you in this case.
I will enter a denial.
Just a second. I'm just writing it so he can see it. Thank you, sir. That's all we have.
I don't know. Maybe the pitch, depending on what frequency. So maybe a feedback. Maybe have to hear a certain frequency. So I don't know what his medical condition entails. All right, is this Spanish interpreter? Yes. All right, we're gonna try that.
Mr. Patrick, you're before the court at this time for an alleged violation, for an arraignment on an alleged violation of probation. The public defender's office has been appointed to represent you in this case.
And will enter a denial.
Hello, Cisco Unity connection.
All right, we're gonna skip over them. We're gonna probably try to call them back mid-morning, around 10 if we can, 10:30. We're still here, otherwise we'll recall them at 1. No, they're busy. We don't have any interpreters. They'll have, yeah, they should have somebody at 1. Because it's at 2 o'clock they start injunction hearings, so we can't call after 2. But at 1 o'clock, there should be somebody available at 1. All right. Good morning, sir. Can you tell me your name?
Marcus Buckley.
Mr. Buckley, you're here in 2021 CF 3164AO on 2 charges. The first one is battery by strangulation, domestic violence, and the other one is battery, domestic violence. The judge signing your warrant has already found probable cause for your arrest.
Yes, sir.
I'm going to set your bond in this case in an amount of $1,000 as account 1, $500 as account 2. Condition of your bond is you have no contact with the victim.
Yes,
Must
sir.
maintain a separate residence from the victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at the location.
Yes, sir. Quick question.
1 second. Yeah, strike do not return. No weapons, no firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You have any questions about a no contact order, sir?
No, sir, I understand.
All right. All right, appoint a public defender to represent you. Have a great day, sir. Good morning, ma'am. Can you tell me your name?
Jasmine Cole.
Ms. Cole, you're here in 2020 CF 3198 AO on a charge of possession of cocaine. Look at me. Possession of methamphetamine and battery domestic violence. I did review the charging affidavit in this case. I did probable cause for your arrest. I have a witness in the witness booth. Can you tell me your name?
Khadija Tompkins.
Could you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right. Can you tell me how you know Ms. Cole?
That's my girlfriend.
All right. And do you want to have contact with her?
Yeah.
Are you afraid of her?
No.
If something like this were to happen again, do you feel comfortable contacting law enforcement?
Yeah. But, never mind.
All right, ma'am. And Ms. Cole, in count one of this, I want to set your bond amount of $1,000. Count two, an amount of $250. Count three, an amount of $250. It's going to come with pretrial release supervision. You have no hostile contact with the victim in this case. So, no hostile contact means this. You can have disagreements. You can have arguments. Those arguments cannot turn threatening. They cannot turn violent. They cannot come to the point where the victim's going to call law enforcement or somebody that sees or hears you all arguing is going to call law enforcement. Because if that happens, you're going to be violating my court order. You're going to spend a lot of time here with me in Orange County Jail. Do you understand that?
Yes.
Excuse me.
You're not allowed to possess any weapons or firearms. Any weapons or firearms need to be turned over to law enforcement within 24 hours of your release. You're not allowed to possess any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. I'll give you 30 days for any narcotics testing before that begins. After that point, the testing will resume. Yes, ma'am.
Can you ask if she need to buy her out?
I can't hear you.
Can you ask if she need to buy her out?
Yes, she can bond out.
I'm saying, can you ask her if she need me to buy her out?
Yes, I do.
Yes.
Okay.
Bond her out. All right. Well, you guys can have contact, so you just can't be hostile.
Right.
All right? So it's an explanation. Arguments, fine. Disagreements are okay. We live in a world where there are going to be disagreements. We're not going to be able to agree on everything. But you cannot turn violent. They cannot turn threatening. Somebody hears you all arguing. Somebody sees you all arguing. If somebody calls the police, she's going to be arrested. You understand that?
Yes, sir.
All right, have a great day. Good morning, ma'am. Can you tell me your name? So cover your face. Cover your face.
Megan Oba.
Ms. Oba, you're here in 2021 CF 3173 AO on a charge of aggravated assault, domestic violence, and battery domestic violence. The court did review the charging affidavit in this case. I did find probable cause for your arrest. I'm going to set your bond in count one in the amount of $500, count two in the amount of $500. Condition of your bond that you be supervised by pretrial release supervision, that you have no contact with the victim in this case, to maintain a separate residence from the victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at the location. You must not possess any weapons or firearms. Any weapons or firearms need to be turned over to law enforcement within 24 hours of your release. Did I miss any conditions? Is there no weapons, no maintain separate residence, no contact? All right. Ms. Oba, do you have any questions about the no contact order?
No, sir.
All right. All right, have a great day, ma'am.
Thank you. You too.
Ruffin Elijah, medical, Your Honor.
All right. I want to appoint the public defender to represent Mr. Ruffin in 2021 CF 3178AO.
Will waive, Your Honor.
All right, the court did review the charging affidavit in this case for the charge of aggravated battery on a pregnant person, domestic violence. Did find probable cause for his arrest. Going to set his bond in the amount of $50,000. Condition of, $50,000. Condition that he had no contact with the victim, no return to her residence, that he not possess any weapons or firearms. Any weapons or firearms he has needs to be turned over to law enforcement within 24 hours of his release. He is out on bond for the same offense in 2020 CF 15111AO, or bond and PTR. Of course, going to revoke that bond and PTR. Going to set a new bond at $0. Same conditions, no contact with the victim. In that case, no return. May not possess any weapons or firearms. Need to be turned over to law enforcement within 24 hours of his release. All right, can you tell me your name, sir? Your name? What happened to Mr. Bell? At James Bell?
Yes.
Oh, sorry. Oh, apologize. I gave the clerk more than one thing. All right, apologize about that. I'm sorry, tell me your name one more time. All right, Mr. Isvandera. Say your last name for me again. Villarenda. All right, sir, you're here in 2021 CF 3199AO on 2 charges. The first one is false imprisonment. The second one is the battery domestic violence. I did review the charging affidavit. In this case, I did find probable cause for your arrest. I have a witness in the witness booth. Ma'am, can you tell me your name?
Antonia Villa.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, can you tell me how you know Mr. Juan?
He's my husband.
All right. Do you want to have contact with your husband?
I do.
Are you afraid of him?
Yes and no.
What's yes and no?
I guess sometimes I am, but then other times I'm not. Just, I don't know how to explain it.
Okay. Has anything like this happened in the past?
No, I lied. That we had one incident before, but it was years ago, but nothing like this.
All right. If something like this were to happen again, do you feel comfortable contacting law enforcement?
Do I feel uncomfortable?
Do you feel comfortable contacting?
Oh, yes.
All right. Did drugs or alcohol play a role in this incident?
No.
All right. All right, Mr. Vieira, I'm going to set your bond at count 1 in the amount of $1,000, count 2 in the amount of $500. Condition of your bond, you be supervised by pretrial release services, that you have no contact with your wife during this time, that you maintain a separate residence from her. I give you a one-time return with law enforcement to retrieve any personal items you have at the location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Do you have any questions about the no contact order, sir? All right. I'm going to appoint the public defender to represent you in this case, and we'll get you on to your next court dates. Have a great day. Yes, ma'am.
I had a couple of questions. Because we do have a child involved,
Yes.
how can I let her visit him?
Well, that's what I'm going to let you talk to the division judge about, because I don't have enough. One, I don't know if you have a third party to which you all can exchange the, exactly. So that may be an issue. So there may be some other ways that the division judge is open to allowing that to happen at a time-sharing facility run by the Department of Children and Families or something like that. I'm not sure of what they're going to be comfortable with. So I want you to get in front of the division judge. You can talk to his public defender, talk to the circuit judge that's actually handling this case, and they'll have better resources and tools to make that happen and have a better plan to put in place.
And how long is the no contact order?
Until that circuit judge changes the order.
Okay, and then also I needed to know if I needed to bail him out today.
Say again?
I needed to know if he needed me to bail him out today.
Did,
Can you have a bank card, check card, something you can post money yourself? Or you need her to do it for you?
It's okay with that?
I will do it.
Okay, that's fine. Just, you can't be in contact with each other until that circuit judge allows it to happen.
And so that's like not even text, phone call.
Nothing, zero. Because if you do, you're gonna get him in trouble. He's gonna be spending time here with me at the Orange County Jail. Do you understand that?
Okay.
All right. Have a great day. Good morning, sir. Can you tell me your name?
James Bell, sir.
Mr. Bell, you're here in 2021 MM 1865AO on charge of battery domestic violence. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. I'm going to set your bond in this case at the amount of $50,000. Condition of your bond that you had no contact with the victim in this case, that you do not return to her residence, do not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You are out on release in 2021 CF 111AO for charges of false imprisonment and battery by one prior domestic violence involving the same victim. The court's going to revoke that bond and release in that case. It's going to set a new bond at $0. Same conditions, no contact, no return, no weapons, no firearms. I want to appoint a public defender to represent you in all your cases. Have a great day, sir. Yeah, no, because obviously that didn't work. Good morning, ma'am. Can you tell me your name?
Trina Clark.
Ms. Clark, you're here in 2021 MM. Sorry, oops. You're here in 2021 MM 18889AO on charge of battery domestic violence. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. I'm going to set your bond in this case amount of $250. It's going to come with pretrial release supervision, that you have no contact with the victim in this case, that you maintain a separate residence from the victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at the location. You do not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You must not possess any drugs or alcohol without a valid prescription. You will be subject to random drug and alcohol testing at your expense. I'll give you 30 days from any narcotics testing to begin. Before any narcotics testing begin, I will allow you to return to.
I can't hear you. I'm not hearing clearly. Sorry.
Can you hear me now?
Yes.
All right. Ma'am, you're here in 2021 MM 18889AO. Sorry, 1889AO on charge of battery domestic violence. I reviewed the charging affidavit. In this case, I did find probable cause for your arrest. I want to set your bond in this case in the amount of $250. It's going to come with pretrial release supervision. I'll allow you to return to New York in this case. You must not have any contact with the victim in this case. You need to maintain a separate residence from the victim. I'll give you a one-time return to that residence with law enforcement to retrieve any personal items you have at the location. You are not to possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You may not possess any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. I will give you 30 days before any narcotics testing begins. But this is gonna come with this warning about you going back to New York. Florida extradites people from everywhere around the world, all right? But from New York, from the Northeast, we get a lot of people visiting here in Orlando because of, we have a nice tourist destination here. However, if you violate my court orders while you're in New York, they're going to put you on a bus. It's going to take you about 3 months to go from jail to get back down here to Florida to deal with this case. You understand that?
Yes.
All right.
I have one question.
All right, well, I'm going to point the public defender. I'll talk to Ms. George about the question you have. Ms. Davis, this next case, was she interviewed? No, next case.
She wasn't.
I need to find a digital way to do it then. You can do it. I mean, you can do it. It's just they don't want to spend the money to do it. Yeah, it's not. Because all it is a PDF autofill form. Just click.
Thank you, Your Honor.
All right. All right, thank you, man. Have a great day.
Thank you, sir.
All right. Good morning, ma'am. Can you tell me your name?
Sandra Cabello.
Ms. Cabello, you're here in 2021 MM 161AW on a charge of battery dating violence. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. I'm going to set your bond, in this case, amount of $250. It's going to come with pretrial release supervision, that you have no contact with the victim in this case, that you maintain a separate residence from the victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at the location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Do you have any questions about the no contact order, ma'am?
No.
I'm going to appoint the public defender to represent you in this case. Have a great day, ma'am.
Thank you.
Danielle Gus is medical, Your Honor.
All right, this is 2021 MM 18884AO. Mr. Fernell Gus, I'm going to appoint the public defender to represent him.
Will waive, Your Honor.
All right, Mr. Gus is here on charge of battery domestic violence. The court did review the charging affidavit. In this case, I did find probable cause for his arrest. Going to set his bond amount of $50,000. Condition of his bond that he had no contact with the victim, no return to the scene. Must not have any weapons or firearms. Any weapons or firearms he has need to be turned over to law enforcement within 24 hours of his release. He's out on bond in 2020 CF 13158 AO for charges of battery, domestic violence by strangulation, bat Leo, and several other tampering to hinder communications with a law enforcement involving the same victim. Of course, going to revoke that bond. Going to set a new bond at $0. Same conditions: no contact, no return, no weapons, no firearms. Good morning, sir.
Salih Karam is medical, Your Honor.
Mr. Salim Karim is going to appoint a public defender to represent him in 2021 MM 164AW.
Will waive, Your Honor.
All right. He was arrested for the charge of domestic battery. I did review the charging affidavit. In this case, I did find probable cause for his arrest. Going to set his bond amount of $500. It's going to come with pretrial release supervision that you have no contact with the victim, maintain a separate residence from the victim. I give him a one-time return with law enforcement to retrieve any personal items he has at the location. He must not possess any weapons or firearms. Any weapons or firearms need to be turned over to law enforcement within 24 hours of his release. He must not possess any drugs or alcohol without a valid prescription. All right. Can you tell me your name, sir?
Aria Williams.
Mr. Williams, you're here in two matters. The first one is 2021 MM 1882AO on a charge of battery dating violence. You're also here in 2021 MM 113AA on a charge of resisting officer without violence. The court did review the charging affidavits in those cases and didn't find probable cause for your arrest. I'm going to set your bond in 2021 MM 1882AO, an amount of $500. It's going to come with pretrial release supervision that you have no contact with the victim. You maintain a separate residence from the victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at the location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And state, are you want to make an offer as to the resisting case?
Not this time, Your Honor.
All right. All right, sir. As to the resisting case, I'm going to set your bond in that case amount $250. It's going to come with pretrial release supervision with the same conditions. When appointed public defender represents you in both cases, have a great day, sir. Good morning, ma'am. Can you tell me your name?
Heather Buford.
Ms. Buford, you're here in 2021 CT 329AE for a charge of driving license suspended as a subsequent offender. And you're also here in 2021 MM55AE on a charge of possession of drug paraphernalia. I did review the charging affidavits. I did find probable cause for your arrest. State, is there an offer to resolve the cases?
Yes, Your Honor. As to the Dwellis, it's an adjudication, credit time served. And as to the possession of drug paraphernalia, I've already filed a no information. May I approach the clerks?
Okay. All right, was it no information? I just want to be clear. Is no information contingent on the plea, or there's no information in the case regardless?
Regardless.
Okay. All right, ma'am. You can resolve. Actually, you can still resolve both cases. So there's just no offer on that other case. I just want to be clear, because just because she filed no information doesn't mean she can't resolve the case. So I just want to make sure you're not making an offer on the paraphernalia case.
No, the paraphernalia case is closed. She can plead to the Dwellis if she would like, and it's an adjudication, credit time served.
All right. I think everybody misses the idea. No information based on the case law and the way the rule reads. It's just saying that we're not filing the case right now. I can still file on the case within the speedy trial window and still prosecute the person for that crime. So I'm making sure that she is not pleading, she's not making an offer on the paraphernalia case.
No, Your Honor.
Because you're not intending to file right now.
Yes, Your Honor.
Okay. All right, ma'am. The offer from the state of Florida to resolve your driver's license suspended case is an adjudication of guilt. It's credit time served. It's going to be a court cost of prosecution amount of $306. Do you want to take that offer to resolve that case today?
Yes.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Put your hand down. Ma'am, you're here in 2021 CT 329AE for a charge of driver's license suspended as a subsequent offender. That is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that?
Sir.
Do you want to enter a plea of guilty or no contest to resolve your case today?
Yes, sir.
Yes, she needs to be printed.
You want to
enter a plea of guilty or no contest to resolve your case? There we go. Do you understand by entering a plea of no contest, you're going to give up the right to have a trial in this matter where the state will have to prove your guilt beyond a reasonable doubt?
Yes, sir.
You understand you give up the right to have an attorney represent you at a trial?
Yes, sir.
At a trial, you can challenge the state's evidence. You can question the state's witnesses. You can call witnesses on your behalf. Do you understand that? If there was a witness you wanted to call and that witness did not want to come to court, the court can use subpoena power to make that witness appear. Do you understand?
Yes, sir.
You understand you're waiving your right to appeal any errors in this case, except the court's jurisdiction over you and the sentence I'm going to impose.
Yes, sir.
All right. Do you understand you're waiving your right to remain silent as to this charge? Do you understand that this charge at a later date can be used against you to enhance your sentencing up to a third-degree felony? Do you understand that?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
Yes, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
Yes, sir.
You understand by entering this plea that if it's not a United States citizen, it could subject you to deportation?
Yes, sir.
All right. I did have an opportunity to review your charging affidavit in this case as well as your driving record. I do find a factual basis for the entering of your plea. I'll accept your plea of no contest. Find that your plea is freely and voluntarily entered. I'll adjudicate you guilty of the charge. I'll give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. The court costs and costs of prosecution in this case are $306. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You got 30 days from today's date to appeal your judgment sentence in writing. As the 2021 MM55AE, the state's filed no information as to that charge, so I'm going to release you on your own recognizance as to that count. All right, have a great day, ma'am.
Does that mean I'm going home today, sir?
Yes, ma'am.
Okay, thank you.
Can you tell me your name, sir?
Ismael Ortiz.
Mr. Ortiz, we're here in 2021 MM 1887 AO on charge of providing false information to law enforcement. You're also here in 2021 CT 243 AW on charge of no valid driver's license. I did find probable cause based on the charging affidavits I have in front of me for those 2 cases, but I'm going to ask the state of Florida if they have an offer to resolve both of your cases today if you would like.
Yes, Your Honor, it's an adjudication credit time served on both.
All right, sir. The state of Florida is offering you an adjudication of guilt, credit time served in this case. Do you want to take that offer today?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, none but the truth, so help you God? All right, you can put your hand down. Sir, you're here in 2 matters. The first one, 2021 MM 1887 AO, in charge of providing false information to law enforcement. That is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. You're also here in 2021 CT 243 AW on charge of no valid driver's license. That is a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that? I can't hear you. Do you want to enter a plea of guilty or no contest to resolve both of those cases today?
No contest. You gotta tell.
Do you want to resolve the cases today?
He understands.
All right. Do you want to enter a plea of guilty or no contest to resolve the cases today?
Yes, sir.
Which one? No contest or guilty?
Guilty.
You understand by entering a plea of guilty, giving up the right to have a trial in this matter, where the state would have to prove your guilt beyond a reasonable doubt in each case.
Yes.
You understand you give up the right to have an attorney appointed to represent you in each case. At a trial, you can challenge the state's evidence. You can question the state's witnesses and call witnesses on your behalf. Do you understand that?
Yes.
If there's a witness you wanted to call, then that witness did not want to appear, the court can use subpoena power to make that witness appear. Do you understand?
Yes.
Or you understand you're waiving your right to remain silent as to these charges?
Yes.
You understand you're waiving your right to appeal any errors in this case, except the court's jurisdiction over you and the sentence I'm going to impose?
Yes.
Are you under influence of any drugs, alcohol, or medication at this time?
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes.
All right, sir. I did have an opportunity to review the charging affidavit in both cases. I did find a factual basis for your plea in both cases. I accept your plea of guilty in both cases. I'll start my sentencing with 2021 MM 1887 AO. I want to adjudicate you guilty as to that charge. I'm going to give you credit for the 2 days that you spent in Orange County Jail with 2 days credit time served. The court cost of prosecution in that case of $273. In 2021 CT 243 AW, I want to adjudicate you guilty as to that charge. I'll give you credit for the 2 days that you spent in the Orange County Jail. The court costs and costs of prosecution as to that charge are $306. I want to combine both of those costs for payment. I'm going to give you 2 years from today's date to make that payment directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in each case. Do you understand?
Yes.
All right, have a great day, sir. It seems like you have a warrant or some kind of other hold that may be holding you here, so I don't know if you're going to be able to leave today. Yeah? Yes, ma'am. You're going to be fingerprinted as to the misdemeanor case. All right.
Okay, so you got one. That's fine.
All right.
Raymond
Yes. All right.
Amon Cody, East Behavior.
I'm
Amon Cody.
2021 MM444AO. Mr. Amon is supposed to be here for arraignment on charge of petty theft. He's represented by the Public Defender's Office. Do you want to waive, Ms. George?
Yes, we'll waive and enter a plea of not guilty, Your Honor.
I will set for Division 84.
Division 84 pretrial conference, April 12th at 9 a.m. in 4B.
Good morning, sir. Can you tell me your name?
Roberts.
What's your full name?
Deshaun James Roberts.
All right. Mr. Roberts, you're here in 2021 MM101380 on a charge of petty theft or a prior theft conviction. Ma'am, if we're in the audience, can you please cover your face? That is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and $1,000, and a $1,000 fine. You're represented by the Public Defender's Office. Is there a plea or you want to enter on behalf of your client, Ms. George?
Here's an offer from the state.
Would you like me to put the offer on the record, Your Honor? It's a withhold of adjudication, credit time served, no return to the Walmart at 3101 Princeton Street, and cost of investigation to OPD in the amount of $162 and $162.05.
Yeah, OPD.
We're going to enter a plea of no contest, and we're going to accept the state's offer, Your Honor.
All right. All right, Mr. Roberts, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Sir, you can put your hand down. Sir, you're here in 2021 MM101380 on charge of petty theft with a prior theft conviction. Okay, I'm just going to put this out here. I'm not going to accept this withhold, but everything else is fine.
Okay, Your Honor. When I looked at his history, I didn't see any other prior petty thefts. I know he has.
Do we file information in this case, or is this a notice to appear? It's somehow you got arrested on for a failure to appear.
We filed it, Your Honor.
What was the case that they listed for him as the prior on the information?
He said all of them were dropped. He said this is the only petty theft he has.
No, he had one from Osceola County that he just time served on March the 4th.
March 8th.
Also,
I'm interested more of, that's not going to change what I want to do, but I want to make sure that he's pleading to the proper charge.
Okay, Your Honor, we'll accept the state's offer, or the adjudication.
Yeah, sure. He did plea in Osceola on the 4th to in jail arraignment and to an adjudication credit time served and no return.
All right, sir. Do you understand? No, stay with me. That the state made you an offer of a withhold. The court's not willing to accept that based on the charge you're facing. You understand that?
Yes, sir.
Or that they're going to be adjudicated. It means you can be convicted of this petty theft. All right. You understand that a third or subsequent arrest for this, that if you're convicted of that, that can increase your penalty up to a third-degree felony. You understand that? All right. All right, sir. According to Ms. George, you're telling me that you want to enter a plea of no contest. Is that correct?
Yes, sir.
All right. Do you understand by entering a plea of no contest, you're going to give up the right to have a trial in this matter where the state is going to prove your guilt beyond a reasonable doubt?
Yes, sir.
You understand you're given the right to have an attorney appointed to represent you at this trial?
Yes, sir.
At a trial, your attorney can challenge the state's evidence. They can question the state's witnesses and call witnesses on your behalf. You understand that?
Yes, sir.
If there's a witness you wanted to call and that witness does not want to appear, the court can use a subpoena power to make that witness appear. Do you understand? Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
Yes, sir.
Do you understand you're waiving your right to appeal any errors in this case except the court's jurisdiction over you or the sentence I'm going to impose?
Yes, sir.
Do you understand you're waiving your right to remain silent? Hear you.
Yes, sir.
Do you understand you're waiving your right to remain silent as to these charges?
Yes, sir.
He said yes, sir.
Okay, I can't hear you, I'm sorry. There's a big vent blowing right here, so it's hard for me to hear you guys out there. All right, sir. Do you all stipulate to a factual basis?
Yes, Your Honor, for the purpose of the plea.
Based on that stipulation, the court is going to find a factual basis for the entering of your plea. I'm going to accept your plea of no contest, finds your plea is freely and voluntarily entered. I'm going to adjudicate you guilty of the charge. I'm going to give you credit for the 36 days that you spent in the Orange County Jail with 36 days credit time served. There is a cost of investigation of $162.05 to Orlando Police Department. I'm going to impose this court cost, the cost of prosecution, in the amount of $273. There's a $50 public defender application fee and a $50 public defender lien. I'm going to combine all those costs for payment. I'm going to give you 2 years from today's date to pay that money directly to the clerk in full. You must not return to the scene of this location. You have 30 days from today's date to appeal your judgment, sentence, in writing. You understand that, sir?
Yes, sir.
All right, have a great day. All right, you're going to try to interpret. Who's this? Who's this person? Who is this? Why is he here? To do what? These cases closed.
Yeah, we already.
Mr. Art?
Wait, is he here? Do you have any, Mr. Royal, do you have any other cases other than the case you played yesterday?
Yeah, he has a battery, Your Honor, I believe. But it's not set for arraignment today.
Okay. I just want to make sure we weren't holding you for no reason. All right. Have a great day, sir. Yeah, you pled, the case we have on the docket today, you pled, so we don't need to do anything on your case. All right. You already pled to the case yesterday.
No, they didn't let him plead.
They didn't let you plead yesterday?
No.
Yes, he did.
He pled on the 16th, Your Honor.
He pled already.
Well, I guess not yesterday,
He had-
2 days ago.
Yep.
And you have another case that's open. So the other case is open, we can't resolve that today.
No, the other case is closed.
Yeah, we closed, I'm saying, the other case is closed. The case you're here for today was the case that was closed the other day. So you got put on the docket by error, by mistake, all right? I do need fingerprints for, Mr. Roberts.
Good morning, Your Honor. This is Laura Royal, State Certified Interpreter, already previously sworn.
Mr. Royal, this is Judge Bain calling from the BRC. We're gonna get our interpreter cases done a little early today.
Yes, Your Honor.
All right. I have a defendant with a headset on. Can you see if you can make a connection?
Sí.
Connections established.
All right, sir, can you tell me your name?
Alexander Vega Alonso.
Alexander Bella Onso.
Sir, you're here in 2021 MM 1879AO on charge of trespass after warning. That is I did review the charging affidavit in this case. I did find probable cause for your arrest. I'm going to ask the state of Florida if you have an offer to resolve your case today.
This is Mr. Vega Lanzo?
Yes.
Yes, Your Honor. An adjudication, credit time served, and no return to Oak Ridge Plaza.
Sir, do you want to take the offer from the state of Florida of an adjudication of guilt, credit time served?
Sí.
Yes.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
That's correct.
All right, you can put your hand down, sir. Sir, you're here in 2021 MM 1879AO on charge of trespass after warning. That is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that?
No, no entiendo eso.
No, I don't understand that.
The maximum penalties for the charge you're arrested for, trespass after warning, is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that?
Sí. Sí.
Yes.
Do you want to enter a plea of guilty or no contest to resolve your case today?
Sí, me dio tiempo servido que me iban a dar hoy, ¿verdad?
I was told that I was going to get time served. Is that correct?
Yes, but you got to enter a plea, which you got to enter a plea of guilty or no contest.
No me opongo.
No contest.
You understand by entering a plea of no contest, you give me the right to have a trial where the state had to prove your guilt beyond a reasonable doubt.
Sí.
Yes.
You understand you give the right to have an attorney represent you in this case.
Sí.
Yes.
Are you under influence of any drugs, alcohol, medication?
No. No. No.
You said no. I think I heard you say no.
I'm sorry. I did say no. It didn't go through?
Yeah. And then yeah, no. Okay. And then have you now or in the past been diagnosed with a mental health illness?
No.
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
No.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Sí.
Yes.
All right, sir. I did review the charging affidavit in this case. I did find a factual basis for the entering of your plea. I accept your plea of no contest. I find your plea is freely and voluntarily entered. I'll adjudicate you guilty of the charge. I'll give you credit for the 2 days that you spent in Orange County Jail with 2 days credit time served. The court costs and costs of prosecution in this case are $273. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence to writing. Have a great day, sir. No, sir. All right. Good morning, sir. Can you tell me your name?
Raúl Omar Claudio Alcocer. Raúl Omar Claudio Alcocer.
I'm sorry, Your Honor. I'm getting the echo.
You gotta get the microphone closer to him. Nope. Nope. That microphone. Yep. Closer to him. Yep. There you go.
Raúl Omar Claudio Alcocer.
Raúl Omar Claudio
Alcocer. Alcocer.
Al parecer
Alcocer.
Álvaro Cel. I'm sorry. I can't catch it through the mask.
It's fine. Sir, you're here in 2000 for a few matters. The first one is 2020 CF 9549AO. You're here for a failure to appear warrant. The judge signing your warrant set your bond at $0. You're also here in 2020 CF 3218AO for another failure to appear warrant. The judge in that case set your bond amount of $0. You're also here in 2020 CF 7848AO for a failure to appear warrant. The judge in that case set your bond amount of $5,000. You were arrested on a warrant in 2020 CF 10229AO for charges of tampering to hinder communication with law enforcement, battery, and assault. The judge signing that warrant has already found probable cause for your arrest. I'm going to set your bond at count 1 in amount of $2,500. Count 2, $500. Count 3, $500. Condition of the bonds, you had no contact with the victim. You not return to the scene of the location. That you not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law
Sorry,
enforcement.
Your Honor. The interpreter's going to have to respectfully ask that you please slow down.
I'm sorry. Sorry. I got on a roll there. Apologize. Where'd you leave off?
With the last bond.
Okay. Well, I'll start by conditions of the bond. This: you had no contact with the victim. You not return to the scene. You not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in all your cases. Talk to Ms. Davis, make sure I didn't miss any case.
Yes,
Case that I
you
missed.
did. You have a 21 MM 1878 case.
Yeah, there it is. No, I missed something. All right, here we go. So in 2021, MM 1878AO, you're arrested in that case for charges of false information, possession of cannabis, possession of drug paraphernalia, and resisting officer without violence. I'm going to stay your bonds as to those counts, amount of 500, 100, 100, 100, and 100. And condition your bond that you not possess any drugs or alcohol without a valid prescription. And then you have a out-of-county warrant from Osceola County for a failure to appear in 2020 CF 2402AO. In that case, the judge in that case set your bond at $0. You also had 2018 MM 8571AO. And for a failure to appear, the judge in that case set your bond amount of $1,500. All right. Still going to appoint the public defender to represent you in your cases if you are not already appointed.
Your Honor, I missed a few of those, if you don't mind.
Which ones?
I missed the 18 8571.
8571 is a failure to appear warrant. The bond amount on the warrant is $1,500.
Okay. And I believe the only other one I missed was the 20 CF 2402.
The Osceola County case, the judge in that case, a failure to appear, set his bond at $0.
And I believe I also missed 20 CF 3218.
3218 was a failure to appear warrant, $0 bond.
Okay. Thank you, Your Honor. I'm sorry.
Oops, sorry. Came apart, apologize. All right. Good morning, sir. Can you tell me your name?
Buenos días, mi nombre es Milton Julián. Buenos días, mi nombre es Milton Julián de Río Febles.
Good day. My name is Milton Julián del Ríos Febles.
Sir, you're here in two matters. The first one is 2021 MM 112AA for charge of possession of drug paraphernalia. You're also here in 2021 CF 3175AO on charge of possession of cocaine. I did review the charging affidavit in these cases, and I did find probable causes for your arrest. I want to state your bond as set as the cocaine charge, an amount of $1,000, and to the drug paraphernalia charge, going to set your bond in an amount of $100. Condition of those bonds is you not possess any drugs or alcohol without a valid prescription. I'm not going to take any action on your 2021 MM54AA case. Have a great day, sir.
Buenos días.
Good day.
All right, Madam Interpreter, I think that was my last one.
Very well, Your Honor. I will disconnect.
All right, thank you.
Your Honor, she's here for Chanel Gus. He's medical.
Some of you already did?
Yes.
For Gus?
Chanel.
Is it a
The last
Gus.
felony DV? Or
for now?
DB. Misdemeanor DB.
Okay.
Well, they gotta pull the paperwork, so I gotta.
Okay.
All right, while we're waiting, ma'am, can you tell me your name?
Good morning, Your Honor. My name is Leisha Gaskin. I'm the victim in this case.
All right, can you raise your right hand and be sworn in?
Yes, sir, I can.
You solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, none but the truth, so help you God?
That is correct, Your Honor.
All right. Ma'am, I think I already addressed the defendant's case, but Is there anything else you wanted to tell me or you heard about?
The reason why I wasn't able to attend when his initial court date, when his initial time was present, because I was downtown at the courthouse. I had some personal matters to resolve there. So I couldn't be at two places at one time.
Understand?
So as soon as I got finished over there downtown courthouse, I immediately came here. And I really wanted to be present because I want to know what was the verdict. What was
the
said.
verdict? He was arrested for domestic violence battery.
Yeah.
I set his bond and I think an amount of $50,000.
How much?
$50,000.
$50,000?
Yes, ma'am. I then ordered him again, like he was ordered before in his other case to have no contact with you, to not be at your residence, which is what had been ordered previously, and to not possess any weapons or firearms. He had another case that he was out on bond, which is 2020 CF 13158 AO case, which I believe you are the same victim in that case from what I remember reading the warrant for that case. And the judge in that case had already ordered him to have no contact with you. I revoked that bond. I said his new bond is $0 with the same conditions, that he had no contact with you, may not return to your scene, not possessing weapons or firearms.
Okay. So you are aware that he also was out on bond for battery on a law enforcement officer too, right?
The case involving the battery domestic violence by strangulation, Bat Leo, all that case, I revoked that bond.
Okay, because I had bonded him out. Honestly, I had bonded him out, and I called the bondsman last night after everything happened, and I told the bondsman that I didn't want to oversee that bond no more, and I wanted to go off the bond.
Yep, so his bond is gone in that case.
Thank you.
Yeah, no problem. I think he has trial in that case, I believe, next month, so.
Okay, thank y'all.
All right, have a great day. All right, does anybody have anything else?
No, Your Honor.
No, Your Honor.
There she is. All right, it is 1:46, March 18th, 2021. Court is back in session. If I could please have the attorneys for the parties put their appearance on the record.
Taylor May on behalf of the Office of the State Attorney.
Letitia George on behalf of the Office of the Public Defender. No, they said he's still on the market. He's still on the market? Yeah. I thought they got it. No, I think they're gonna do a buyout. They gonna I don't think he'll go to the Lakers.
Cause the Lakers, they're not pushing for him. They want Okafor.
They gonna get him? For real. This is crazy.
Well, I didn't realize it wasn't the same person. don't know the answer to that.
You know the case is saying that, though. It'll be this year.
So why is it on Christopher? Yeah, that's how it was for me too.
Right.
But I just looked at Atkins. I'm gonna put it on Jermaine. Let's put him back. And Christopher was second, right? That's where it was for me. Unless you guys looked at. Oh, actually, he's first. Oh, he's first. Please tell me your name.
Christopher Atkins.
All right. This is case number 21MM1862. You're here charged with trespass, failing to leave a property after being ordered by the owner. I'm going to appoint the Public Defender's Office to represent you. There is probable cause. What's your middle name?
Zaire.
All right, that's right then. Does the state have an offer?
Yes, Your Honor, an adjudication, credit time served, and no return to the Wawa.
Ms. George, have you had an opportunity to speak with your client about that?
Your Honor, I have, and I explained it was up to him if he wanted to accept the state's offer or not.
And did you talk to him about the rights he's giving up by entering a plea?
No. Can we approach, Your Honor?
Yes.
Can we approach?
All right, Mr. Atkins, there is probable cause here for your arrest. I've appointed the Public Defender's Office to represent you. You understand you can enter a plea of not guilty, and we'll continue this for a hearing at a later time. You can enter a plea of guilty or no contest. If you enter a plea of guilty or no contest, I will sentence you today, but you're giving up your right to remain silent, your right to testify on your own behalf, your right to have a jury trial when one is required. So if you enter a plea of guilty or no contest today, you're going to give up those rights. Do you want to enter a plea of guilty or no contest, or do you want to enter a plea of not guilty and talk to the Public Defender's Office more about your case?
If I plead not guilty, will I go back to jail?
So you're in jail. I will give you a bond on this, so you'll be able to bond out.
Does that mean someone outside of jail have to bond me out?
Yes, unless you have access to money.
Because I'm on the streets and I don't have anyone.
So if you don't have a way to post a bond, then yes, you'll sit in jail.
If I plead no contest, will I be released?
Was the state's offer credit time served?
Yes, Your Honor.
Yes, I'll sentence you to credit time served and you'll be released today.
No contest.
But you understand, just because you're going to get out today, you're entering a plea of no contest. So you're telling the court that you're not admitting the charge, but you think it's in your best interest to admit, to enter a plea of no contest, and you're not going to contest the matter.
The way the system is designed, it doesn't roll in my favor, so I have to plead no contest.
You don't have to do anything, sir. You have all of those choices up to you. And because I appointed the Public Defender's Office to represent you, you have an advocate. So if you think you have defenses to raise in this case, you can talk to your attorney further about it.
Ma'am, one of the main reasons why I have to leave is because they have my items as contaminated items. I don't have anyone on the outside, so if I don't leave, my items are going to be thrown away for no reason.
I don't know about your items, sir.
I have the sheet of paper right here. I can show you. What I'm saying is, if everything is designed against me, I have reasonable information that I could tell you that I'm not guilty, but if that's for me to stay in jail, then I cannot do that. I have to plead no contest so I can get my stuff.
You don't have to plead no contest, sir. You can plead not guilty, and I won't sentence you today. And you can talk to an attorney about the case, and they can raise defenses on your behalf. Actually, this system is designed to protect your rights as an accused. So if you want to enter a plea of no contest today, I'll have you raise your right hand, swear you in, and I'll qualify your plea. But if you're telling me that you have no choice, I'm concerned about you entering a plea of no contest today.
My apologies. I don't want to lie, and
No, I don't want you to lie.
and I don't want anybody else to go through whatever I'm going through right now, because I could give you more information as far as my case, but I know I'm not able to do that right now because I'm not in a position to do so. I'd rather plead no contest.
All right, raise your right hand, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir. You're telling me that you want to enter a plea of no contest today. You understand that by entering a plea of no contest today, you're going to be giving up your right to remain silent, your right to testify on your own behalf at a jury trial where one is required, your right to present defenses, call witnesses to present those defenses, your right to challenge the evidence the state might produce against you. You're giving up those rights today to enter a plea of no contest. Is that what you want to do?
Yes, ma'am.
Has anyone threatened you or promised you anything to get you to enter this plea?
No, ma'am.
Are you under the influence of any substance that would affect your ability to understand what you're doing?
No, ma'am.
Have you ever been declared incompetent?
Describe?
Have you ever had a doctor evaluate you and declare you incompetent?
No, ma'am.
Do you have any other mental health issues this court should be aware of?
No, ma'am.
You understand that if you're on probation, this plea could violate that probation?
I don't understand.
So I don't know if you're on probation. I'm not suggesting you are. But I have to tell you that if you are on probation anywhere and you enter a plea, that plea could be used to violate your probation.
I am not on probation.
All right? You understand that if you're not a United States citizen, this plea could subject you to deportation.
Yes, ma'am. I have a question.
Yes, sir.
If you had the ability to get a trespass warning, would you take the one without the seal or the one with the seal?
I'm sorry, ask me that again.
If you had the opportunity to get a trespass warning, would you take the one with the Florida seal or the one without the Florida seal?
I'm not sure I understand your question.
A trespass warning has a Florida seal on it.
You mean if I was trespassing, if I was in a place I was not legally allowed to be,
Or
I would leave.
or police told you to leave and you say that you would want a trespass warning and the police didn't want to give you a trespass warning, so you called other policemen to come to give you a trespass warning, and they didn't give you a trespass warning, so they arrested you?
I would leave, sir.
Okay. Then no contest.
All right, and you've had an opportunity to speak to your attorney, and you don't want more time to speak to an attorney about this case.
Is that what no contest means?
Yes.
Yes, ma'am.
At this time, how do you wish to plead to the charge of trespass, failing to leave property upon order by owner?
The owner didn't talk to me. It was just the police.
All right, how do you wish to plead to the charge of trespass?
No contest.
I'll accept your plea of no contest. I do find it's freely and voluntarily made. I'm going to adjudicate you guilty, give you credit for
2 days.
2 days in jail. Sir, I have to order that you pay court costs in this matter. I'll give you a year to pay them. I understand you said you don't have anyone and you're on the street, so I'll give you a year to pay the court costs. I'm also going to order that you're not allowed to return to the Wawa gas station. Do you understand?
Yes, ma'am.
Do you have any questions for me?
How much do I owe?
It's around $300, do you know? Yes.
It'll be $323.
It's $323. So you have a year to pay that. Good luck, sir. Please tell me your name.
Osiris Brown.
Your Honor, no information has already been filed in this case. May I approach the court?
Yes, this is case number 21MM1880. At this time, sir, the state is dropping the charges against you. Have a nice day.
Oh, Your Honor, are you gonna
Ms. Gibson.
Wait,
address his bad?
I'm not going to take any action on the out on bond case. They dropped this one. Have a nice day, sir.
Do I have bond?
Yeah, I'm not revoking your bond on your out on bond case, but this case was dropped, so you don't have to pay a bond. Yes, sir. Please tell me your name.
Lorenzo Holmes.
In case number 21MM1888AO, you're here charged with possession of drug paraphernalia and possession of cannabis under 20 grams.
Your Honor, this is another one that I filed a no information notice on. May I approach the clerk?
Yes. At this time, sir, the state is dropping the charges against you. Have a nice day.
All right.
Please tell me your name.
Bradley Langford.
Sir, you're here in case number 21MM1885AO, charged with resisting an officer without violence and trespass on property other than a structure or conveyance. At this time, I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. Your bond will be $500 on count 1, $100 on count 2. You're not allowed to return to
West Church and Nashville Avenue, the city park.
the city park there, sir. And at this time, I'm going to take no action on your out on bond case. Good luck, sir. Please tell me your name.
Tiffany Enos.
In case number 21MM40, a capias was issued for your arrest for failing to appear for arraignment on a charge of possession of drug paraphernalia. The bond on that is $1,000. Does the state wish to be heard?
This is Ms. Enos?
Yes.
Yes, Your Honor, I filed a no information as to the possession of drug paraphernalia. However, the state has no offer on the false ID to Leo. May I approach the court?
Yes. No offer on the what? And she also has an out-of-county warrant. Hold on. I have a failure to appear. All right, so they're dropping the charge of possession of drug paraphernalia. You also have a warrant out of Lake County in 20MM877 for failing to appear on false information to a law enforcement officer. Your bond is $4,000. We'll notify them that you're here.
Yeah, I think that they are aware.
And then, I don't see what other case to which you're referring.
That's all, Your Honor, was that.
Okay, I'm not going to take any action on her out on bond case at this time. All right, good luck, ma'am. I'm not revoking your bond.
Good afternoon, Your Honor.
Yes. Please tell me your name.
Yamil Ayala.
You're here because a warrant was issued for your arrest in case number 19CT4831 for violating probation for a DUI charge, in that you failed to keep appointments scheduled with your probation officer in November, December, and 2 in January, that you failed to pay the $50 a month, and you did possess or consume an unlawful substance, to wit marijuana. as evidenced by the urinalysis test. At this time, there is no bond authorized on that warrant. I'll appoint the Public Defender's Office to represent you. Good luck, sir.
What? Does she want to go ahead and deny the BOP and I can set up for her?
Do you want to enter a denial, counselor, and set it for a...
We'll enter a denial.
All right. Please tell me your name.
Oscar Jose Gonzalez.
You're here because in case number 2013 CT 7388, a warrant was issued for your arrest for violating your probation and that you failed to pay the $50 a month, you failed to complete the DUI counterattack school, you failed to complete the victim awareness program, and you failed to complete 50 hours of community service.
Your
Your
Honor.
bond, hold on, sir. Your bond authorized on that warrant is $2,000. I'll appoint the Public Defender's Office to represent you. Yes, sir?
I did do half of the classes. I got my license, as a matter of fact, in Miami.
You'll have to explain that to the other judge. This is a warrant and I'm not going to change it.
Okay.
But if you have some defenses to the violation, make sure you tell your public defender because they'll talk to the state about it and maybe they'll dismiss it. I don't know.
Okay.
Do you want to enter a denial?
Yes, I'll enter a denial.
Are there any VOP status hearing dates?
Your Honor.
Yes, sir.
I got Colorado holding me. Is this bond, am I clear to go if I pay this bond?
I don't know if you have other holds.
He does, yeah.
You can post this bond and in this case, you'd be released. You have other holds or not?
He does. He has a hold for Colorado.
Okay, so no, you won't be released then.
Okay, thank you.
Yes, sir. Good luck. Please tell me your name.
Amazing Abdel-Jabbar.
In case number 21 CF 317980, you're here charged with 2 counts of aggravated assault with a firearm, resisting an officer without violence, possession of methamphetamine, fleeing or attempting to elude a police officer. I'm going to appoint the Public Defender's Office to represent you. Counselor, did you wish to be heard?
Yes, Your Honor. On the aggravated assault with a firearm, the 2 counts, we're arguing that there is no PC. According to 784.021, Florida statute, it states that in order to have an aggravated assault with a firearm, there needs to be threat by word or act to do violence. The only thing in the arrest affidavit that we have is that they were outside and they heard a noise across the street, and they saw the neighbor in the upstairs window holding a dark object. There's nothing to say that he pointed that at them. They couldn't even make out the words that were being said, and there was never a weapon recovered. And because of that, we're arguing there's no PC for an aggravated assault with a firearm.
Your Honor, there was no weapon.
What says the state?
Your Honor, can I have a 24-hour reset to do some research?
I'm sorry, say that again?
Can I have a 24-hour reset if you're not inclined to find PC?
Your Honor, we would just argue that based on here, we have the statement by both victims stating what they heard. I know the state can have 24 hours. I just don't see why it's reasonable in this case, what other additional information they could gather. I know, you said you need to do research. Could we recall it? Would that be enough
I'm able
time?
to research while I have to write everything down.
Oh, okay.
All right, so Counselor, can we go back to your argument? I pulled out the statute.
Mm-hmm.
What statute were you reading?
784.021.
An aggravated assault is an assault with a deadly weapon without intent to kill or with an intent to commit a felony, which is punishable by is a felony of the 3rd degree, punishable as provided in 775. So what language were you quoting? It's not in 021.
Oh, from what I read off of the Florida jury verdicts, it states that the state has to prove a threat by word or act to do violence.
So are you looking at assault, 784.011? An assault is an intentional, unlawful threat by word or act to do violence to the person of another.
Right.
Coupled with the apparent ability to do so. And doing some act which creates a well-founded fear in such other person that such violence is imminent.
Under that definition, we would argue that the act of the clicking of the gun, which the victim argued, or at least told the officer that he knows the distinct sound of the firearm being operated, the clicking sound that the victim heard would be enough of an act that would create reasonable apprehension of harm. And they were close, they are neighbors, so that act of imminent harm could easily be taken out.
And I would argue that no one saw a firearm. They heard clicking, which could have been anything. They said across the street, if I'm not mistaken, in the arrest affidavit, they saw him through a window and saw a dark object and heard clicking. No one ever found a gun on him. They searched the house, never found a gun. Neither one of the victims stated that they saw a gun. They alleged they heard this clicking sound and believed that to be a gun.
Well, it also says holding a dark object that he believed was a firearm. So he saw it by sight, he believed it was a firearm, then he heard the clicks, which reinforced his belief that it was a firearm.
Your Honor, it says he window holding a dark object that he believed to be a firearm.
Right. So by sight, he thought it was a firearm. Then he heard the clicking, which confirmed his belief that he thought it was a firearm.
Right. However, there was never a firearm. There's only an allegation that he saw a dark object and heard a clicking and believed that to be a firearm.
A firearm doesn't have to be found.
He's a past victim of gun violence, so knows the distinct sound of a firearm being operated. Both were placed in fear of their life. They could hear the defendant yelling something, and they were running, being fearful of being harmed.
Right, Your Honor. However, we're arguing that they could not make out what the dark object was. They didn't hear any threats. There was no threat being made. It literally says he was in the window holding a dark object. It didn't say he was pointing that dark object at them. They just heard clicking and believed it to be a firearm. They didn't say he pointed that gun at me and threatened me, or he was pointing it at them when he was screaming or clicking the gun. It just literally says he was standing in the window holding a dark object that was making a clicking sound.
Yelling at them.
Yelling at them something.
To that, Your Honor, I would just say that according to the jury instruction, they have to be intentionally or unlawfully threatened, and in this case, it's by act. So the clicking, it doesn't have to be pointed at them, and they just have to appear to have the ability to carry out the threat. And they're in close enough proximity that the threat could be carried out. And the item, the dark object that the victims believe is a gun, could easily be pointed at them, but it's not a requirement. It just has to have the ability to carry out said threat.
So I understand that the jury instruction comes from the statute, but I'm reading the statutory language, which is very similar to what you're quoting. It's an unlawful threat by word or act to do violence. So are you arguing that there's no probable cause because
of the
if there is hold on. If there is a gun, waving a gun is not an aggravated assault unless you point it at someone?
No, Your Honor. I'm arguing, one, that they allege a dark object. There is no firearm recovered. Neither one of the victims state that it is a firearm. They just say they think it's a firearm. So we're charging him with the aggravated assault with a firearm. No firearm is recovered. They never see a firearm. They hear clicking sound. That could be anything. I could tap on the window. That could sound like a clicking sound. And he's screaming. So am I saying that there may not be PC for aggravated assault? There could be PC for aggravated assault. I'm just saying that there is no PC for aggravated assault with a firearm.
Where would they have recovered the firearm, counselor?
They searched the house. There was no firearm. They searched the car, and there was no firearm.
Did you read the paragraph that says he exited the residence, got into a 2018 white Mercedes, left the area in haste, ran over the stop sticks that were deployed by Officer Hansen, continued to drive, then later attempted to return to the residence? They had to get a chase helicopter out?
Right.
So in all of that time, there was not a possibility that a firearm could have been discarded?
No, I'm not saying that. I'm saying that
Right.
there is no allegation in here that would show that he was holding a firearm. It just says they see a dark object. That's it.
So I think I understand your argument, and I think if you're arguing that the state can't get past reasonable doubt on this, you might have a great argument. But I think there is probable cause.
Okay.
So I'm finding there's probable cause in this case, sir. Does the state wish to be heard as to bond?
I'll leave that within your discretion, Your Honor, given the facts of the case and his history.
Ms. George, do you wish to be heard as to bond?
Your Honor, we would just ask that you look at the fact that the only conviction he has in Florida is a DUI in marijuana possession. His last failure to appear was in 2008.
All right, your bond on count 1 will be $5,000. Count 2 will be $5,000. Count 3 will be $100. Count 4, $150. Count 5, $150. You're not allowed to possess a weapon of any kind, a firearm or ammunition. Do you understand?
Yes, ma'am.
You're not allowed to have any contact with the victims or any witness in the case. Do you understand what no contact means?
Yeah, of course.
So you can't talk to them in person, electronically, through an app on your phone. You can't send a message through a friend or neighbor.
So that would be the police then, correct? That was I guess those are the victims.
You can't send a message through anyone, is what I'm saying.
To who?
To the victims or the
Who are
witnesses in the
victims,
case.
Dear? I'm sorry, Your Honor. Who are the victims? Just I
Right.
need to know. That way I don't make a mistake and send the victims.
State.
I believe he was referring to the victims of the fleeing and attempting to elude that they're law enforcement.
I can't hear you at all.
I believe he was referring to the victim, a victim in the fleeing and eluding, which are law enforcement officers.
No,
think that's
just
kind
tell
of-
me the names of the victims in the case.
The alleged victims are Kimry Gottwald and Onyx Ramirez.
You can't have any contact with them. Do you understand what that means?
I have no idea who those two people are. But yeah,
All right.
okay, no problem, Your Honor.
No contact. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Do you understand?
Okay, yeah, of course.
Are there any other conditions the state would request?
No, Your Honor.
Wait, you're out on bond. Are you out on bond?
No,
Oh,
ma'am.
no, that's a different person. All right, good luck, sir.
Thank you. Have a good day, Your Honor.
You as well. Please tell me your name.
Joseph Alvarez.
A capias was issued for your arrest in case number 20 CF 13936 for failing to appear for a plea hearing on a charge of possession of fentanyl, possession of a controlled substance, and resisting an officer without violence. The bond authorized on that capias is $2,500 on count 1, $500 on count 2, and $100 on count 1. On count 3, I'll appoint the public defender's office to represent you.
He has a private attorney, Lisa Figueroa.
Oh, you already have an attorney? Then I'll not appoint the public defender's office to represent you. I am going to revoke your ROR in case number 20 CF 12, is that a 942?
Yes, Your Honor.
Yes, Your Honor.
I'm revoking your ROR. Your bond in that case will be $1,000. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Do you understand? Yeah. Good luck, sir. Yes. Please tell me your name.
Jermaine Atkins.
All right, Mr. Atkins. You're here in case number 2013 CF 2012BO. A capias was issued for your arrest for delivery of cannabis more than 20 grams. There is no bond authorized on that capias. I'll appoint the public defender's office to represent you. And I'm not sure, can the attorneys please approach? Did you see these emails, Rebecca?
Yes, I forwarded them to your JA. From my understanding, I'm guessing he's supposed to serve time on this case. So,
Oh, it's at sentencing. It doesn't say that. So has he been sentenced? Oh, to be imprisoned for a term of 60 months.
No, ma'am. No, ma'am. Can I say something, ma'am?
You can say anything you want, sir. It's being recorded and can be used against you later.
Okay, what happened was I got arrested with my cousin in 2013, and what happened was they had the ID messed up in the paperwork. When I went to jail in Haines City in Polk County, Florida, my name is Charles Atkins, and my cousin's name is Jermaine Atkins, and they had messed up our paperwork in the system. And I went to prison in 2020 and got out, and Orlando messed me up. They didn't ever come and get me and bring me back. This charge been going on since 2013. I never even signed 50 months, ma'am. I supposed to came and did 10 months in Orlando County Jail, and what happened was when I got out of prison, Orlando, they never come back and get me. So I've been...
Wait, I thought you told me your name was Jermaine.
No, that's what they got on my ID. My real name is Charles Lee Atkins. You could look it up in Polk County. I just came from Polk
Right, that's
County
what I have
jail.
too.
Yes, ma'am. I'm not lying, ma'am.
I believe you.
Yes, ma'am. So I was trying to say, for the record, any kind of way could I even get a standard bond or something? I can get out and try to fix this because this wrong. This charge been going on since 2013.
So this capias was issued by another court. I can't change the capias,
Yes, ma'am.
but I'm not going to order him remanded to DOC at this time.
Yes, ma'am.
You want me to put that on the IA order?
Yes.
Not to be remanded to DOC?
Right.
Yes, ma'am. Because when I went to Polk County Jail, I've been out ever since 2013, and these charges, this 8 years ago, I don't understand how I'm still being held for a charge that I did not do.
Because the charges that you failed to appear for a hearing 8 years ago.
Yes, ma'am.
And so it's been outstanding for 8 years.
Yes, ma'am.
So just because it's 8 years old, you still have to answer for it. It doesn't disappear.
Yes, ma'am.
But what I think we need to do is, it looks like he had regional, Office of the Criminal Conflict and Regional Counsel
Yes, ma'am.
representing him. I think we need to get in touch with them
Yes, ma'am.
because I want to make sure before we remand you to DOC that it's correct. So I don't want to do that today.
Yes, ma'am. But excuse me, ma'am. Can I say?
Yes, sir.
I never signed for 60 months.
Right. The allegation is you were supposed to come to court to be sentenced for a crime.
Yes, ma'am.
And you didn't come to court, so the judge sentenced you anyway, even though you weren't there. So you're saying you didn't sign for it. Well, you wouldn't have because you weren't in court.
Okay.
Okay, hold on. I don't want you to say anything that incriminates you in any way. I'm not asking you questions. I just want you to understand that's what this is.
Yes,
So
ma'am.
the capias is you didn't come to court, so you wouldn't have known this is what happened.
Yes, ma'am. But if I didn't know if they had me in Polk County Jail, they brought me from Orlando to Polk County. So how can I appear when they had the paperwork mixed up with another ID that I came? Me and my cousin got arrested at the same time for these charges. So when I went to Polk County Jail, then when I got released, they didn't never bring me back here to face that. I tried to turn myself in. They told me I did not have no warrant because they had my name up on another name, so it wasn't clear it was my fault.
Were you in Polk County Jail? How long were you in Polk County Jail?
For 4 months. And when they let me out of Polk County Jail, I tried to turn myself into it. They told me I didn't have no warrant. The warrant was under Jermaine Atkins instead of Charles Lee Atkins. So that was the state came at, ma'am. So it wasn't never my fault. That's why I'm saying I got cancer right now, and my mama facing, she got leukemia. I was out fixing her up, I had a good job and everything, ma'am. I got cancer right now, stomach cancer. I'm trying to see if any kind of way get a bond or standard bond so I can be released, so I can be able to help my mom.
I can't legally change that capias. Another judge signed it and it has no bond. But what I'm going to do is we're going to contact your attorney from back then, and the state, because what I want to do is see if we can get to the bottom of this. I don't know that there's going to be a solution you're going to be happy with, because the answer may be you're going to the Department of Corrections for 5 years. I don't know that can be changed. But you're not going to do that today because I want to make sure that we get this right before we send you to Department of Corrections. Okay?
Yes, ma'am, but I understand that, but I understand how can I get 5 years and for coming back to court when they had me in Polk County Jail, and then I didn't know, they ain't no way I could have turned myself back in when they had my name mixed up in the computer on another name.
So the sentence isn't because you didn't come to court.
Yes,
The
ma'am.
habeas is because you didn't come to court. But the sentence is for the crime, delivery of cannabis. Now, hold on, don't say anything.
Yes, ma'am.
I'm not asking you to tell me about that delivery of cannabis, okay? I just want you to understand, what happened is, you had that criminal charge.
Yes, ma'am.
You were supposed to come to court and be sentenced. The court sentenced you anyway, even though you weren't there.
Yes, ma'am.
But I can't change that. This is a different court, and I can't change it. So I just want to see if we can get to the bottom of it. But I'm telling you, I don't know that anything can be done, but I want to be sure that it's correct.
Yes,
So
ma'am,
before,
but if I can show you my paperwork that I had took.
hold on, look, squeeze your mask like this on your nose, and then it'll quit riding up on your eyes.
I had took, when I had came in 2013, I had took 10 months, but to turn myself in for 10 months in the county jail. So when I went to Polk County and had the hold, I got out of Polk County jail and I supposed to came back to court. When I was supposed to came back to court, they had my name on the Jermaine Atkins, and what happened was, they didn't never come back and get me. When I turned myself in, they say that I didn't have no warrant. It was the warrant was on a whole other name, so it clearly wasn't my fault, ma'am.
I understand what you're saying. I think that you might have some great things to talk to your attorney about and maybe raise that in front of the judge.
Yes, ma'am.
But because this is a different court, I don't have jurisdiction to change what that judge did. So what I want to do is try to get your attorney and the state attorney back in front of that judge so they can sort it out.
Yes, sir, but any kind of way, ma'am, if I had took a deal for 10 months, how do I get to 5 years and I took a deal for 10 months?
I don't know. It was a different judge who ordered it. So I don't know what that judge was thinking when they did that. I don't know your criminal history. I don't know anything about you. But the best thing I can do for you is get your attorney and the state attorney back in front of that judge before we send you to DOC. So that's what I'm going to try to do, okay?
So, okay, I understand that, but if I took a deal for 10 months and then they give me 5 years, wouldn't that be wrong, ma'am, if I took a deal for 10 months? I took the deal in this county jail, in this court for 10 months.
I don't know the answer to that. What I have is a capias, and I have a sentencing sheet that says for a term of 60 months. That's all the information I have on your case.
Yes, ma'am.
So I really am trying to do the best thing I can for you.
Yes, ma'am.
But I don't know what's the end result may still be that you're going to the Department of Corrections for 5 years. I don't know if I can have any impact on that at all. But I want to make sure that your attorney and the state talk to the judge before we send you to DOC, okay?
Okay, yeah, one more question, ma'am.
Yes, sir.
You say I got sentenced for 5 years, but if I took a deal for 10 months and then they gave me 5 years, I mean, that's kind of be like sending me out the guideline when I took a deal for 10 months for possession of marijuana with a ticket to sell. They didn't even carry 5 years at the time. They only carried 10 months. And I had the score sheet and the paperwork back at home to my mama, still got my paperwork. And it said 10 months that I took the deal for. So I don't understand how can I get 5 years when I took a deal for 10 months, ma'am.
So the maximum sentence for this charge is 5 years in prison.
Yes, I would have never took 5 years for a 10
Right.
short.
But you weren't there, so the judge sentenced you in your absence, which is lawful. The judge can do that. So I don't know. I don't know the answers to your questions. The people who know that would be your attorney and that judge. So I'm going to try to get you back in front of them.
All right, is it going to be for this county jail? This is what I took the deal at this county for 10 months.
I don't know the answer to that. The sentence says 60 months, which would be the Department of Corrections, not Orange County Jail.
Orange County, so I'm still lost, man, because I got arrested in this county, and I took a deal in this county jail for 10 months, so I don't know how the Department of Corrections, because it seems 5 years, and I took a deal in this county jail.
So what happens is, if you're charged with a felony,
Yes, ma'am.
and you're sentenced for more than a year anywhere in the state of Florida,
Yes, ma'am.
you go to the Department of Corrections. You don't stay in the county jail for 5 years. So it may be that your attorney communicated to you that the state's offer was 10 months and you were supposed to come to court and take that deal. Maybe that was the state's offer. And then you would have served 10 months in the county jail. I don't know the answer to that.
I took the 10 months. That's what I'm saying.
But I don't have access to that information is what I believe what you're telling me.
Yes, ma'am.
But I can't see that. I'm telling you the only thing I can see.
Yes, ma'am.
So we got to get your attorney and the state back in front of this judge
Yes, ma'am.
to look at it because I can't change anything. I can't even give you a bond. There's no bond
It
authorized.
don't even say, it don't even tell you what judge I had or public defender, so that's kind of, I mean.
You had an attorney, you didn't have the public defender, you had the regional conflict counsel.
Yes, ma'am.
Jeffrey Stone.
Yes, ma'am. So, how can I get in contact with Stone, and how can you get in contact with that judge and let them know that
I'm going to do that.
That'd be kind of wrong for them to give me 5
Sure.
years, and then I took 10 months. That's.
I'm going to get in touch with them.
Yes, ma'am. 'Cause I took 10 months, so like that'll be like kind of sentence me like. I mean, I took 10 months and then I'm coming back for 5 years. I mean, that's kind of wrong, right, ma'am, for me to take 10 months and then they give me 5 years. And
I don't know enough about the details, so this is the best I can do for you, sir, okay?
you can let me know when I come back to court, then, ma'am. I'm just.
Well, I don't know if you'll come back and see me. So I'm going to call, and we're going to see if we can get your attorney and the state attorney back in front of this judge.
Yes, ma'am.
All right, good luck,
How
sir.
long will it be before I just got to sit on dead time? You don't.
You just have to wait.
Wait.
I don't know the answer to that.
Thank you very much, ma'am.
Yes, sir, good luck. I'm going to keep that one for now, because I got to take it back to my chambers. Do you need it first? I just need to take it back to my, or I need a copy of it in my chamber so I can work on it. Because and the emails, I guess. Yeah, that's fine.
Okay. Yeah.
Because I gotta know who to get in touch with and how.
Your Honor, I believe it's now in front of,
I can't hear you, what?
I believe it's now in front of Judge Calderon in Division 12.
Judge Calderon?
Yes.
Thank you. Thank you. I will get in touch with him this afternoon then. Please tell me your name, sir.
Troy Austin.
You're here charged with possession of cocaine and trespass on property after warning in 21 CF 3184. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. Your bond will be $1,000 on count 1, $100 on count 2. You're not allowed to possess or consume illegal substances or have contact with any known drug dealers. Do you understand? You're also not allowed to return to 222 Mary Street. Oh, wait, is that West Orange Habitat for Humanity?
I believe so, Your Honor.
All right, you're not allowed to return there, sir. Do you understand? Good luck, sir. Please tell me your name.
VJ Barrett.
I'm sorry, what?
VJ Barrett.
You're here in case number 21 CF 3043. A warrant was issued for your arrest for grand theft of a motor vehicle and trespass in a conveyance. Probable cause has already been found. Your bond is $1,000 on count 1, $500 on count 2. You're not allowed to have contact with any victims. You're not allowed to return to the scene. As to your out on bond case.
Your Honor, I believe that case number is actually incorrect.
It's what?
I believe that case number is incorrect. I think it's 20 CF 7417. I believe they omitted the 7 somehow.
I have 714. Oh, I have 7417. Yeah, that's what I have.
On mine, I just have 417.
I'm inclined to revoke his bond, Counselor. Do you have any argument as to why I should not?
Your Honor, his new charge is a nonviolent offense. From what I'm seeing, all of his the convictions he has in Florida are nonviolent. Yeah, I don't see any violent offenses unless I'm missing it. That he's been convicted of.
What says the state?
Your Honor, if you are inclined to revoke, we would just ask that you set a new bond. Due to the nature of the charges, as defense counsel already stated, they are nonviolent. So if you are inclined to revoke, we would just ask that you set a new higher bond. Also, in regards to that case, we only filed on the possession of cocaine, not the meth and cocaine.
All right, at this time, I'm going to take no action on your out on bond case. Good luck, sir.
Thank you.
Yes, sir. Please tell me your name.
My name is Frankie Belfer.
In case number 21 CF 2934, a warrant was issued for your arrest for failing to update your Florida driver's license as a sexual offender. The bond authorized on that warrant is $2,500. You're required to report as a sex offender within 72 hours of your release and register. Do you understand, sir? Yes, sir.
Ma'am, he's saying I failed to report, but when I came in on Friday, he said it in front of the deputy when they arrested me. When I came in February, that I didn't report. I said, well, how I couldn't, because see, every 6 months, I report. So when I report in, they was arresting a guy that was there, and they were going through something. So he had to make a mistake, because I reported. And
that sounds like you have some defenses you might want to raise. I'll appoint the public defender's office. You can talk to them about your defenses, sir, but probable cause has already been found because a judge already issued this warrant. You have a bond, so you're able to bond out, but you must maintain your sex offender reporting requirements while you're out on bond. Do you understand?
What did you say, ma'am?
I said you must maintain your sex offender reporting requirements while you're out.
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Wesley Brand.
In case 21 CF 3170, you're charged with possession of cocaine, possession of cannabis under 20 grams, and possession of drug paraphernalia. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. Your bond is $1,000 on count 1, $100 on count 2, $100 on count 3. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
As to your out on bond case, 20 CF 14445, you're charged with possession of cocaine with intent to sell or deliver and possession of a firearm by a convicted felon. At this time, I'm revoking that bond. Good luck, sir. Please tell me your name.
Dominique Brown.
A warrant was issued for your arrest. In case number 21 CF 2611, charging you with sale or delivery of cocaine. Your bond is $7,500. You're not allowed to possess or consume illegal substances or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
I'll appoint the public defender's office to represent you. As to his out on bond cases, they're both delivery of cocaine.
Yes, Your Honor.
I'm revoking your bonds in both of those cases. Good luck, sir.
Charles Gordon, you refuse court.
All right, that's 21 CT 709. Counselor, I'm going to appoint your office to represent him.
Will waive.
That's a capias. His bond is $2,000. 21 CF 3165, I'll appoint the public defender's office to represent him.
Will waive, Your Honor.
He's charged with 9 counts of possession of ammunition by a convicted felon. There is probable cause. His bond will be $5,000 on count 1, $150 on each of the subsequent counts. 65.
Your Honor, count 9 is possession of a firearm. On that case.
It is. The others are possession of ammunition.
Yes, Your Honor.
That bond will be $4,000. He's not allowed to possess a weapon of any kind, firearm or ammunition. In 21 CF 3167, I'll appoint the public defender's office to represent him.
Will waive, Your Honor.
There is probable cause. His bond is $4,000. He's not allowed to possess a weapon of any kind, firearm or ammunition.
You should have another case, Your Honor.
I have another one? Wait. Hold on. Yes. Hold on. 5, 6, 7, 6, 6. Okay, so 21 CF 3166 AO.
Charles Gordon
He's here, Your Honor.
And he wants to come in now?
Yes.
All right, bring him in. He refused.
So you still want to keep it as a refusal, you would take it off?
No, because if he's coming in, we'll see him. Sir, tell me your name.
Charles Gordon.
All right, sir, you're here in 21 CT 709. You failed to appear for arraignment on a charge of operating a motor vehicle without a valid driver's license.
Ma'am, they had the wrong address on the summons. I just contacted the people that used the address from my ID instead of asking me what my new address was, and I has no control over that. I've been to the court 2 weeks before the summons and changed my address.
Sir, a capias was issued for your arrest by another judge. I can't change that capias. If you think you have defenses to raise, you need to talk to the public defender's office. I've appointed them to represent you. In that case, your bond is $2,000. In case number 21 CF 3165, you're charged with 8 counts of possession of ammunition by a convicted felon, 1 count of possession of a firearm by a convicted felon. There is probable cause. I'm appointing the public defender's office to represent you in that as well. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Never did.
So you understand what I'm telling you?
Yes, ma'am.
All right, your bond is $5,000 on count 1, $150 on counts 2 through 8, and $4,000 on count 9. In case number 21 CF 3167, you're charged with possession of a firearm by a convicted felon. I'm appointing the public defender's office to represent you in that case as well.
How I got a possession of firearm? I've been in jail. I haven't seen no affidavit. I have not spoken to anybody.
You'll want to talk to your public defender's office about that. There is probable cause here. I'm appointing them to represent you in this one as well. Your bond is $4,000. In case number 21 CF 3166, hold on one second. I'm going to appoint the public defender's office to represent you in this case as well. Can the attorneys approach?
And I got a 1-year-old daughter that I got sole custody of. I told the detective that they sent her over there. They sent somebody over there to get her, bring her to her grandma. Her grandma cannot watch her. Her grandma is 80 years old. I got sole custody of my daughter. I was not at no residence. I've been in jail since this traffic ticket, and now they charging me with a bunch of firearms that I have no idea about, and I do not reside at any of those residences.
All right, thank you, sir. All right, sir, because it's 2 different firearms with ammunition, there is probable cause in this case as well. So your bond will be $5,000 on count 1, $150 on counts 2 through 8, $4,000 on count 9. I've appointed the public defender's office to represent you in each of these cases. You'll want to talk to them about any defenses you think you have so they can raise those on your behalf. Good luck, sir. tell me your name.
Jomika Denson.
You're here in case number 21 CF 3092, charged with possession of a firearm by a convicted felon. A warrant was issued for your arrest. The bond authorized on that is $2,000. You're not allowed to possess a weapon of any kind, a firearm or ammunition. Do you understand?
Yes, ma'am.
I'm going to appoint the public defender's office to represent you.
Well, will the hold be lifted?
I'm sorry?
The hold will be lifted?
I don't know what the hold is for.
No, it won't be lifted. They added a on-view VOP on her.
All right, so it looks like you might already be on probation, and a violation of probation will be coming, so the hold won't be lifted.
And then even though my son stated that was, because my son had got shot on January 27th. So it was like, the SWAT came and hit my house, and my son, once they searched the house, they never found the firearm. So it was me and my son being arrested, and he just got arrested as well, too.
I don't know anything about the facts, ma'am. A warrant was issued for your arrest. Another judge has already found probable cause. So if you think you have a defense, you need to talk to your attorney about it.
Okay.
Your Honor, what was her bond?
It's
So when would the violation of probation occur?
$2,000 bond. Okay, thank you. I'm sorry, what did you say?
So when would the violation of probation occur?
I don't know when it'll come. It's up to probation. They're usually pretty quick about it.
They added it on her.
Oh, they did?
You'll be seen
So,
tomorrow.
all right, good luck. Hold on one second. Please tell me your name.
Tara Ebenezer Dickerson.
In case number 21 CF 3176, you're charged with possession of MDMA. I'm going to appoint the public defender's office to represent you. There is probable cause in this case, ma'am. Your bond will be $1,000. You're not allowed to possess or consume illegal substances or have contact with any known drug dealers. I show that you're out on bond in 3 cases.
If this was like a total accident, it's being taken care of. I am being put on probation. I'm gonna get a year probation for all of that. So if you would allow me to get out on this, so I can complete that, I would.
You have a bond on this case, but I'm inclined to revoke your bond in your other cases. I'm going to ask the attorneys if they have any argument as to why the court should not revoke her bond.
Yes, ma'am. Yes, ma'am.
Your Honor, at least as to the 20 CF 15123, we haven't filed on it yet. So for that one, I would at least ask you to take no action on. The other 2, the Dwellis, I believe she has a status hearing coming up next month. And then the criminal mischief, she has PTC in May. As to those, I cannot speak to due to her history. However, as to the Grand Theft Motor Vehicle possession of MDMA and the paraphernalia, it's not yet filed on. So I'd ask that you take no action. And if you were inclined to revoke, we'd ask that you set higher bonds in those other cases so she can resolve them all.
She's out on bond for possession of drugs. She gets arrested for possession of drugs.
I understand, Your Honor.
I just ask you, please. It was an accident. It wasn't mine. I'm gonna just ask you just for this opportunity, please, madam.
Your Honor, I would just add that she is not a violent offender based on what I see in her history.
She has 4 prior failures to appear, 12 felonies, 19 misdemeanors.
And her last failure to appear was in 2018, Your Honor.
It was when?
It's showing me 2018. I don't know if yours is.
You understand that a condition of bond is that you not commit any new law violations?
Ma'am, I definitely do. I do.
What are the conditions of bond I can place on this defendant to ensure that she won't violate? She's out on bond in 3 cases. She has a lengthy history.
Your Honor, again, you can revoke and increase the bond amounts. That's the only thing that I can recommend. It's showing, it looks like on mine, Your Honor, it's showing that on 2 of the counts, it's a ROR.
Yeah, I'm revoking those.
Is there any way?
In case number, I'm sorry, what?
Sorry. Is there any way for her to do random urinalysis while on bond? Or does she have to be supervised by?
Yes, I can do that. In case number 20 CF 15123, I'm revoking your ROR. Your bond will be $1,000 on, I think it's count 2.
I can double check, Your Honor.
The other 2, it'll be $100. You're not allowed to possess or consume illegal substances. You're going to be subject to random drug screens while you're out on bond. When do they start those if it's not pretrial release?
I believe it's the same.
So it'll be at least 2 weeks. All right. Random drug screens? Yes. 100. No drugs, random screens. In case number 20 CF 12175, I'm revoking your ROR. Your bond will be $500 on count 1, $100 on count 2.
That she was on pretrial release for.
Oh, that's the pretrial release?
Yes, Your Honor.
I'm revoking that. Your bond will be, what did I just say? What did I say the bond was?
500 count 1, 100 count 2.
500, 100. And in all of these cases, you'll be subject to random drug screens. You're not allowed to have any contact with any known drug dealers. Do you understand?
Yes, ma'am.
Good luck.
Are you taking no action as to the Dwellis?
Yes.
And on her case 15123, you said 1,000 on count 1. Count 1 is the grand theft motor vehicle, count 2 is the possession of meth, and count 3 is the possession of drug paraphernalia.
Yes. Count 2 is 1,000. Count 1 and 3 are 100.
Okay.
But I didn't realize count 1 was a felony, so it should be 150. I said 1,000, yeah. B, can we take a recess? Is that okay? All right, court will be in recess for 5 minutes.
You got it? Oh, okay. Oh, yeah, I remember seeing that.
Excuse me, did she do RUA on her new case as well? Or no?
I don't have it. All I have is
For the out
no
on
illegal
bond
substances
cases?
and no contact with
Okay.
known drug dealers for her new 21 CF 3176 case.
Okay.
Lakers, they're playing in it? Who they playing? I don't know who. The Hornets? They're gonna beat them. The Heat just went against him last night. Yeah. Yeah, I know. Yeah. John Morant bad. You see Steph Curry got hurt too? Who, John Morant? Mm-mm.
He was having the tournament. He was on the other side.
Mm-hmm.
And I think it was the trainer
Mm.
from another team.
Mm-hmm.
They said, hey,
Wow, that's crazy. Wow. Yeah, I didn't know that. Yeah, they did. Oh, he killed it. Yeah. Oh, really? That's crazy. Yeah, he is. Can you imagine in a couple of years? Woo. Yeah, he gonna be something to reckon with.
he be having fun.
No, not him. John Morant.
Yeah, I read that. 'Cause he won.
That's what I'm saying. Can you imagine in a couple of years? Yeah, he gonna be so sick. No, did you see? What's his name? Not Lonzo Ball, his brother, LaMelo. He's supposed to play LeBron, and he's like, we're like, how do you feel about when he gets LeBron? He's like, oh, I don't really, I didn't really watch basketball like that or something stupid. And the guy's like, you need to stop. Your whole thing is all about basketball. Yeah, he lied. No, he don't.
You need
It's gonna be about 4.
Look, properly fried. You need a chair. I won't tell that. Sit down in the chair.
That's all I do is stand.
Hey.
If my mom is telling me to sit down, sometimes I don't feel used to this here. You know,
Like, you need to sit.
Oh, no.
You go to sleep.
Thank you. All right. Oh, we're back on the record. I guess I didn't turn it off. I didn't hear it. Yes, yes. In all of the drug cases?
On the new case as well? Okay. Thank you.
No problem.
Thank you. Sir, please tell me your name. Sir, tell me your name.
Jimmy Douglas.
In case number 21 CF 316, can you hear me?
Hold on, Your Honor.
Does it help if I do that?
I have hearing aids at home, but they wouldn't let me bring them.
Okay, he's going to give you the hearing device.
Backwards?
Let's try it now. Can you hear me better?
Yes, ma'am. Yes, ma'am.
All right. In case number 21 CF 3163, you're here charged with 7 counts of possessing material depicting a sexual performance by a child. I'm going to appoint the public defender's office to represent you. I reviewed the probable cause affidavit. There is probable cause in this case. Does the state wish to be heard as to bond?
The state would just ask that you set a reasonable bond given his history. I do believe he just got out of DOC recently. And given the nature of the charges, I just asked for a reasonable bond on all charges.
Does the defense wish to be heard?
No, Your Honor.
Sir, it looks to me like you're on federal probation. I don't know if that's accurate, but you might be on federal probation, so this might violate that probation. I wanted to make you aware. If you're already a registered sex offender, you must maintain sex offender reporting requirements. Your bond will be $50,000 on count 1, $50,000 on count 2, $50,000 on count 3. It's the same, count 4, 5, 6, and 7. You're not allowed to have any unsupervised contact with any minor child under 18 years old. Do you understand?
Yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir. Please tell me your name.
Michael Durham.
In case number 21 CF 3145, you're here charged with fleeing or attempting to elude a law enforcement officer with lights and sirens active, fleeing or attempting to elude law enforcement by failing to obey an order to stop, driving while license suspended, your third or subsequent offense. I'm going to appoint the public defender's office to represent you in this case. Michael Durham. There is probable cause. Your bond will be $15,000 on count 1, $150 on count 2, $150 on count 3. You can't drive without a valid driver's license. Do you understand, sir?
Yes, ma'am.
I show that he's out on bond.
Yes, Your Honor.
In case number 20 CF 2029. Possession of a firearm by convicted felon, aggravated assault with a deadly weapon, tampering with a witness, 2 counts, battery, domestic violence, aggravated assault with a firearm, and tampering with a witness. I'm going to revoke your bond at this time.
Your Honor, we ended up filing on different things, but we did file on 5 charges.
So what are the charges?
Possession of firearm or ammo by a convicted felon, aggravated assault with a deadly weapon, 2 counts of tampering with a witness or hindering communication to law enforcement, and a battery DV.
All right, I'm revoking your bond on those counts, sir. Good luck. Please tell me your name.
Kim Field.
In case number 21 CF 3148, you're here charged with aggravated assault on a law enforcement officer with a deadly weapon, battery on a law enforcement officer, and resisting an officer with violence. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case, sir. Your bond will be $5,000 on count 1, $150 on count 2, $150 on count 3. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Well, what was the charge you said?
I'm sorry?
You said I was arrested for what?
Aggravated assault on a law enforcement officer with a deadly weapon, battery on a law enforcement officer, and resisting an officer with violence.
By any chance, can you get my bond lowered or anything of that nature?
I cannot at this time. I'm not going to at this time, but your attorney can file a motion in front of the trial judge to reduce your bond. Additionally, you're out on bond in 20 MM 4638AO. I'm inclined to revoke your bond, sir. Does the defense have any reason why I should not?
Your Honor, the only thing that I would state to the court is that we do believe there is some mental health issues.
All right, at this time, I'll not revoke your bond on that, sir. Good luck.
Revoke me?
I'm not taking your bond. You still have a bond.
Can you lower the bond for me?
I'm not at this time, but your attorney can file a motion to do that.
5,000?
Yeah, yes, sir. All right, good luck. Actually, hold on. Can I have that back? Oh, no, I'm not. No. Got it again.
Your Honor, can we skip Francis?
Yes, sir.
He's in the restroom.
All right.
Next is Gilbert. He refused court.
All right, this is case number 21 CF 3172. I'll appoint the Public Defender's Office to represent him.
We'll waive, Your Honor.
All right, his bond, there is probable cause. His bond is $2,500. He's not allowed to have any contact with the victim or return to the scene, possess a weapon of any kind, firearm, or ammunition.
Your Honor, he has a second case.
He has a second?
Yes, Your Honor.
I don't have it. I have one case.
Oh,
I mean, he has lots of cases, but I have one case before the court today.
Did you only have the battery 2 prior?
Yes. Mr. Devontae Francis?
Yes, ma'am.
In case number 21 CF 3146, you're here charged with possession of MDMA, possession of drug paraphernalia, and resisting an officer without violence. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. Your bond will be $1,000 on count 1, $100 on count 2, $100 on count 3. You're not allowed to possess or consume illegal substances or have contact with known drug dealers. Do you understand? I'm also going to order that you're not allowed to return to the Quick Mart at 520 South Orange Blossom Trail. Do you understand? Yes. Good luck, sir. Please tell me your name. In 2019 CF 16185, a capias was issued for your arrest for failing to appear for a plea hearing on a possession of cocaine charge. There's no bond authorized on that capias. I'll appoint the Public Defender's Office to represent you. Good luck. Please tell me your name. I'm sorry? All right, in case number 21 CT 2114, you're here charged with driving while license suspended. There is probable cause. I'll appoint the public defender's office to represent you. Your bond on that count will be $500. You can't drive without a valid driver's license, you understand?
Yes, ma'am.
All right, hold on, you got it, you got several cases. In 20531, you're here for a violation of probation. There's no bond authorized. I'll appoint the public defender's office. Then in 21 CF 3187 AO, you're charged with possession of cocaine.
I didn't have no possession of cocaine.
I understand what,
Cocaine in the van, and they said
I can't hear you, ma'am.
they found cocaine in the van. I wasn't in the van.
So I understand what you're saying. You might have some defenses to this and you need to talk to your attorney about it. But at this time, there is probable cause for that arrest. I'm not telling you owned the cocaine or the state can win this at a jury trial. I'm just telling you there's probable cause, okay? But I'm appointing the public defender's office to represent you. Your bond on that will be $1,000. You can't possess or consume illegal substances or have contact with any known drug dealers, you understand?
Yes, ma'am.
And then in case number 21 CF 3189 AO, you're here charged with grand theft of a motor vehicle. Again, there's probable cause for this. I'm going to appoint the public defender's office to represent you. Your bond is $1,000. You cannot have contact with any co-defendants, you understand?
Yes, ma'am.
You can't have any contact with victims, return to the scene, and I think I appointed the public defender. All right, good luck, ma'am. 500.
Hernandez, he's mental health.
All right, 21 CF 3192. Counselor, I'm going to appoint your office.
We'll waive, Your Honor.
Hold on, there is probable cause in that case. Does the state wish to be heard on bond? It's a possession of cannabis.
Yes, Your Honor. I don't see that he has any history or any prior failures to appear, so at this time the state would ask for an ROR.
His last conviction was for a DUI last year, but I think that might be the only conviction he has.
Yes, Your Honor.
And in light of the circumstances, what are you asking for?
An ROR.
I'll grant that. He's not allowed to possess or consume illegal substances or have contact with any known drug dealers. And I'll order that he has to comply with any any physician recommendations, doctor's orders. Doctor's orders, yeah. Please tell me your name, sir.
Joshua Lee Highfield.
You're here because a warrant was issued for your arrest in case number 21 CF 2529 for failure to report and re-register as a sex offender and failure to update your driver's license or identification card as a sex offender. At this time, your bond will be $5,000 on count 1, $5,000 on count 2. You must comply with any reporting requirements that you have while you're out on bond. Do you understand?
Yes, ma'am.
In case number 20 CF 11993 AO, you were out on bond for attempted burglary of a conveyance. Has the state filed it?
Yes, Your Honor.
As?
Attempted burglary of a conveyance. Back in December.
I'm inclined to revoke that, counselor, unless you can give me a compelling reason not to.
Your Honor, I would just add that this shows 0 failures to appear. And as we know, the requirements are easy to violate in Florida. So with the bond and the fact that he has been compliant with his out on bond case, we would just ask that you take no action. It looks like it's an ROR as well, Your Honor, so if you're inclined, you could revoke and increase the bond amount.
All right. At this time, I'll take no action in your out on bond case. Good luck, sir.
What does it mean?
Please tell me your name.
Reginald Montree Jackson.
In case number 21 CF 3191AO, you're here charged with grand theft of a motor vehicle. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. Your bond is $1,000. You're not allowed to have any contact with the victim or the co-defendant in this case. Do you understand?
Yes, ma'am.
In case number 21 CF 3190, you're charged with driving a license suspended as a habitual offender. I'm going to appoint the Public Defender's Office to represent you in that case as well. There is probable cause. Your bond will be $1,000. You can't drive without a valid driver's license.
Yes, ma'am.
In case number 21 CF 3188, you're here charged with possession of cocaine. There is probable cause. I'll appoint the Public Defender's Office to represent you. Your bond is $1,000. You can't possess or consume illegal substances or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
As to your out on bond cases, at this time, I'm going to revoke your bonds in all of them. Your attorneys will have to file motions in front of the trial court. Good luck, sir. Please tell me your name. In case number 20 CF 8435, a warrant was issued for your arrest for fleeing or attempting to elude a law enforcement officer and driving while license suspended. Another judge has already found probable cause. Your bond is $10,000 on count 1, $250 on count 2. You can't drive without a valid driver's license. You understand? In case number 20 CF 84318AO, you're here because a warrant was issued for your arrest for kidnapping, extortion, robbery without a firearm, and vehicle theft. Another judge has already found probable cause. You'll be held on.
Your Honor, we filed other charges on that case.
Oh.
We filed on that in December of 2020. Would you like to?
I don't think I have that information. Yes, what charges did you file?
Count 1 is a kidnapping with intent to inflict harm or terrorize, a life felony. Count 2 is battery, DV, and M1. Count 3 is fleeing and attempting to elude a law enforcement officer, an F3. Count 4 is resisting without violence, an M1. And count 5 is driving while license suspended, an M2.
All right, so as to count 1, you'll be held with no bond. Even while you're in custody, you're not allowed to have any contact with the victim. Do you understand what no contact means? You can't call her on the phone. You can't contact her electronically. You can't ask friends or family members to send her a message. You understand?
I have a question.
Yes, sir.
I've been incarcerated since July 15th, and I was just released 2 weeks ago, stating that these charges were dropped. They were dismissed.
They were not dropped.
So the judge just blankly lied to me, like in my face.
I don't know what you're talking about, sir.
He just released me 2 weeks ago. I've been incarcerated since July 15th.
The allegation in the arrest warrant is that on or about July 10th, 2020, you committed the offenses of kidnapping, extortion, robbery, and vehicle theft. So.
How is that if I'm incarcerated?
You were not at the time. You were incarcerated 5 days after this took place. Based on what you're telling me. I don't know when you were incarcerated.
July 15th.
All right, so this is alleged to have occurred July 10th. So it was 5 days before you were arrested.
June 10th. July 10th.
July 10th. So the state filed these charges. I'm appointing the Public Defender's Office to represent you. So it's no bond on count 1. Counselor, I need you to tell me the counts again that you filed, because the bond amounts I have are with this warrant?
Yes, Your Honor. Count 2 is a battery DV.
All right, so your bond on that will be $100.
Count 3 is a fleeing and attempting to elude an F3.
Your bond on that will be $10,000.
Count 4 is resisting without an M1.
Your bond will be $100 on that count.
And count 5 is a Dwellis M2.
All right, your bond on that will be $100.
What are my charges now?
Right, she just, tell them again, what did the state file?
Count 1 is kidnapping with intent to inflict harm or terrorize. Count 2 is a battery DV. Count 3 is fleeing and attempting to elude a law enforcement officer. Count 4 is resisting without violence. And count 5 is just driving with license suspended.
So on the kidnapping charge, you have no bond. On all of the other charges, you have bond. But even while you're in custody, you can't have any contact with the victim or any witnesses in the case. Once you're released, I'll order that you're not allowed to be within 1,000 feet of the victim. You're not allowed to return to the scene of the crime for any reason at all. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
I still don't understand how I've been incarcerated since July 15th. And I was just released 2 weeks ago.
You'll have to talk to your attorney about that, sir. Good luck. Please tell me your name.
Jose Marty. Jose Marty.
Thank you, sir. In case number 21 CF 3182, you're here charged with destruction of evidence and possession of heroin. I'm going to appoint the Public Defender's Office to represent you. Counselor, did you wish to be heard in this case?
Your Honor, originally, the destruction of evidence charge, however, when I read the statute for 918.13, it was a tampering with evidence or to conceal, if I'm not mistaken.
Wait, say that again?
The tampering with or fabricating physical evidence, altering, destroying, concealing, or removing. And it did state that he threw the drugs, I believe in this case. So originally I had a PC challenge for the destruction of evidence, but it looks like it says destruction of evidence, but it's a tampering with physical evidence. Because when I pull up
Throwing it is enough?
913. 918.13.
Okay, I'm pulling out my statute book.
To alter, destroy, conceal, or remove.
Your Honor, I can speak to this. I also have case law on it.
Just get close to the microphone.
All right. Throwing within the presence of law enforcement when it can be easily picked back up is not enough to tamper or destroy law or tamper with evidence. So at this time, I do not believe there's PC as to that charge.
All right.
Because he did throw in the presence of law enforcement and it was easily reobtained.
Right.
So I do not believe there's PC to that charge.
I didn't think so either when I read that. So I do believe there's probable cause for the possession of heroin charge, but I'm going to ROR you for the tampering, destruction of evidence charge. Your bond on the possession of heroin will be $1,000. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Do you understand?
Yes.
So what say the attorneys as to his 2 out on bond cases? Burglary, criminal mischief, another burglary, petty theft, criminal mischief. I'm going to take no action at this time. Good luck, sir.
It was $1,000 on the heroin, Your Honor?
Yes.
Thank you.
Please tell me your name.
Theodore McCarthy.
I'm sorry, tell me your name one more time.
Theodore McCarthy.
Oh, all right. You're here in 20 CF 7435. A capias was issued for your arrest for written threats to kill or do bodily harm and aggravated stalking with a credible threat. I'll appoint the Public Defender's Office to represent you. You're not allowed to have any contact with the victim or any witnesses in the case. Do you understand what no contact means?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. What says the state as to bond?
Your Honor, he is sitting on an F2 and an F3. And given the nature of the offenses and that it is a victim case, I'll leave it with your discretion. Just as you said, a reasonable bond.
Does the defense wish to be heard?
No, Your Honor.
Your bond will be $20,000 on count 1, $20,000 on count 2. You can't be within 1,000 feet of the victim. Do you understand?
Yes, but can I say something, please?
Yes, you can say anything you want. It's being recorded and can be used against you later.
Ma'am, I've been sitting on this charge since November. November 16th, I was arrested in Hillsborough County, and they just now got me yesterday. Like, is there
Orange County Jail?
Yes, ma'am.
So the coronavirus had a major impact in all of the county's abilities to transport inmates back and forth.
Yes, ma'am.
Because when there were outbreaks of coronavirus, the various facilities couldn't transport.
Yes, ma'am.
So I understand what you're saying. It probably had to do with coronavirus.
Is there any way that you could set a lower bond, please?
Not based on the charges, sir. I'm not inclined to do that. Your attorney can file a motion in front of the trial court, but not at this time.
Okay, can I say something? When I was in Hillsborough County, I filed a writ of habeas corpus myself. The state denied it based on me being there. I then filed a motion to reconsider. Like, I've been trying to get this resolved myself, and nothing's happening. You know what I mean? Like, I don't have an extensive background. I have no felony convictions. Like, I've never been to prison. Like, I'm just tired of sitting.
I understand. You do have a bond now, so that was another thing. The capias had no bond authorized on it. I've changed that at this time. So now you do have a bond.
Okay.
Talk to your attorney as soon as you can. I've appointed the public defender's office to represent you. They can file a bond motion and have a hearing, notice the victim, and the judge can change the bond if they wish.
Yes, ma'am.
All right, good luck, sir. Hold on. We might have to bring him back. I might have missed something. Oh, it does. You're right. I'm sorry. One more time. Thank you. I'm sorry, sir. I missed something. You're also not allowed to have contact with any member of the victim's family. Do you understand?
Yes, ma'am.
Not electronically, no contact at all.
Yes, ma'am.
All right, good luck. Thank you. Please tell me your name.
Frederick Douglass McNeil.
In case number 21CF3181, you're here charged with possession of methamphetamine and possession of cannabis under 20 grams. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. Your bond is $1,000 on count 1, $100 on count 2. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
As to your out on bond case, I'm inclined to revoke it, counselor, unless you can give me a reason not to.
Your Honor.
It's another drug case.
He has no failures to appear. He works full-time. It's a nonviolent offense. And I show the last conviction was in 2015.
Yes, sir.
If I can say something, Your Honor.
You can say anything you want, but I want to make sure you understand that what you're saying is being recorded and can be used against you later.
I understand. I just got the job, and I let somebody hold my car. I just made a mistake, and if I can just continue to keep this job so I don't be homeless, or
Where's your
I'll make sure
job?
I come to court. It's right there at the airport on Boggy Creek. We're doing the new Speedway.
How long have you been working there?
I just started 3 weeks ago, and I just got back on my feet a little bit, and I was going to settle the last claim out of court. But I'll make sure I show up to everything. I just don't want to lose the job and be homeless.
All right, so are you going to be able to post the bond that you have in this case?
Yes, ma'am. It's already posted.
Oh,
I thought I was going to be able to get to work this morning, so
all right. I'll not revoke your bond. Good luck.
thank you.
Don't make me regret it.
You won't, I promise.
Please tell me your name.
Darnell Owens.
In case number 21 CF 3174, you're here charged with possession of cocaine and possession of cannabis under 20 grams. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. Your bond is $1,000 on count 1, $100 on count 2. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
What says the state and the defense as to his out on bond cases? Grand theft, dealing in stolen property, aggravated assault with a deadly weapon, carrying a concealed firearm.
Your Honor, since there are firearm offenses and violent offenses, the state would ask that you revoke, and if you're inclined to set new bond.
Ms. George?
Your Honor, we would ask that you revoke and set a new bond. My client, it shows, is employed. He has 0 failures to appear, and the new charges are nonviolent offenses.
Where do you work?
I work at Taylor Farm and I work at McLeod Tires.
How long have you worked there?
I worked at Taylor Farm for 2 years and I worked at McLeod Tires for like 3 or 4 months. And I got a job interview, I think next week for SGL.
For what?
SGL construction job. Your Honor, may I talk, please?
You can say anything you want. It's being recorded and can be used against you later.
Yes, ma'am. Your Honor, I know I messed up, but Your Honor, I promise I won't mess up again, Your Honor.
I don't know if you want to say much else, sir. That can be used against you later. I just want to make sure you understand that.
Yes, ma'am, I know.
I'm going to take no action in those cases. Good luck, sir.
Thank you.
Please tell me your name.
D'Angelo Parsons.
In case number 21 CF 1992, you're here charged with possession of a firearm by a convicted felon and aggravated assault with a deadly weapon. A capias was issued for your arrest. Your bond amounts are $4,000 on count 1, $2,500 on count 2. You're not allowed to have any contact with the victim or any witnesses in the case or a co-defendant. Do you understand what no contact means?
Yes, ma'am.
You're not allowed to possess or consume alcohol, illegal drugs, or controlled substances without a valid prescription. You're not allowed to possess a weapon of any kind, a firearm, or ammunition. Do you understand?
Yes, ma'am.
In case number 21 CF 3200, a warrant was issued for your arrest for possession of firearm by a convicted felon, carrying a concealed firearm, possession of cannabis under 20 grams, possession of ammunition by a convicted felon, and driving while license revoked. Your bond is $10,000 on count 1, $5,000 on count 2, $500 on count 3, $1,000 on count 4, $500 on count 5. You're not allowed to possess or consume illegal substances or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
You're out on bond in case number 21 CF 1992 for possession of a firearm by a convicted felon and aggravated assault with a deadly weapon. Is that the warrant case?
Yes. I had.
Sorry, I'm asking the state.
Oh, I'm sorry.
I'm not asking you to make any admissions or statements, sir. Sorry. Let me clarify. It's the same charges, counselor. Is that the same case? It is. All right, so no action on that case. Good luck, sir. Please tell me your name.
Jose M. Rodriguez Quinones.
In case number 19 CF 9281, a warrant was issued for your arrest, charging you with attempted first-degree murder with a weapon. There is no bond authorized at this time. I'm going to appoint the public defender's office to represent you. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
Even while you're in custody, you can't call on the phone, you can't send a message through a friend or family member, no contact at all. Do you understand?
Yes, ma'am.
As it's no bond, are there any other conditions the state would request at this time?
Just also no contact with victim's family or other witnesses.
Yes. You're not allowed to have any contact with the victim's family or any other witnesses in the case. Do you understand?
Yes, ma'am.
All right. Good luck. None. Sir, can you hear me?
Yes, sir. Yes, ma'am.
All right. Can you tell me your name?
Charles Rossetti?
You're here in case number 21 CF 3183, charged with aggravated assault with a deadly weapon. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. Sir, were you living with this victim?
No, no, ma'am.
She doesn't live with you?
No.
Wait. But your neighbors?
Yes.
All right. Does he qualify for pretrial release?
Yes, he could qualify.
Does the state object to pretrial release in this case?
Your Honor, since it was a fairly violent offense with a knife, and he was close enough to make contact with the victim, state would object to PTR. And as we don't have victim input here today. And since they're neighbors.
Your Honor, I would just argue that it's showing the last conviction was in 1967, that if you place him on pretrial release, if he violates any of your conditions, he'll be brought right back here before you.
Thank you both. Sir, at this time, I'm going to place you on pretrial release. I'm going to order that you're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
And I understand that you're neighbors.
Yes, ma'am.
But if she comes outside, you go back inside.
Yes, ma'am.
Because you're the one who can come back to jail if you have any contact with her. You understand?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, a firearm or ammunition. Do you understand that?
Yes, yes, ma'am. Can I say something, ma'am?
Yes, sir, but before you do, I want to make sure you understand everything you say is being recorded and can be used against you later.
Oh, yeah.
You understand that?
Yes, ma'am. Yeah.
All right.
I was drinking and I blew it all. I was drinking.
All right, then I'm going to order, sir, that you're not allowed to possess any alcohol,
That's
and you're going to be subject to random alcohol screens.
going to go.
All right, so when you're on pretrial release, it's sort of like being on probation.
Yes, ma'am.
So they're going to subject you to random urinalysis.
Right.
So if you drink, you're coming right back to jail.
Yep.
You understand?
Good thing, ma'am. Yes, ma'am.
Your Honor, given that they're neighbors, I know you can't enforce a no return, but can we do a no return to their house or yard?
Yes. Sir, you can't go to her house for any reason or be in her yard.
I didn't even look over there, ma'am.
Okay, that's the safest.
Yep.
Good luck, sir.
Thank you, ma'am.
Yes, sir. Please tell me your name.
Shauna Shirey.
In case number 21 CF 3177, you're here charged with possession of synthetic cannabinoids. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. Your bond is $3,500. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Do you understand?
Is there any way, because I just started working, Your Honor. I just started my job and everything for the R money. I just started it. I'm trying to do the right thing, you know.
Where do you work?
They are cleaning service. We're cleaning their places. I'm trying. I've got ripped off all my money twice now for a place. I'm trying my best.
Ma'am, I'm not inclined to ROR you. You have a history.
Yeah, but I've never missed court or anything, Your Honor. And I do have, you know, a younger daughter at home. I've not missed.
What says the state?
I've cooperated and everything.
She does not have any other failures to appear. However, she does have a fairly lengthy history here and out of state. Most of it is driving and drug related.
In Delaware, yeah.
Your Honor, she does appear to be employed. It states for 2 months now, and with 0 failures to appear, and it's not a violent offense. We would ask the court to consider that and release her on ROR. If not, Your Honor, just lowering the bond amount.
All right, I'm not going to release you on your own recognizance, but I'll lower the bond amount to $1,000 with the same conditions. Good luck, ma'am. Please tell me your name.
Rufus Thomas.
And you're here in, wait, can you call his attorney? Thomas? We're going to see if we can get your attorney on the phone. In the meantime, what happened to Angelo Talibert?
He bonded.
Bonded, Your Honor.
Okay. What about Charles, Delquan Charles? I had that first and we skipped it.
What's the booking number? 2100.
I'll just give you the whole thing.
Yeah.
This is Judge Gibson. Can you hear me?
Yes, ma'am, I can.
All right, we're here with the State of Florida versus Rufus Thomas. This is case number 21 CF 2891. Would you like to put your appearance on the record?
Rhiannon Arnold on behalf of Mr. Thomas.
All right, sir, you're here because a warrant was issued for your arrest for conspiracy to sell or deliver heroin. The bond authorized on that warrant is $7,500. You're not allowed to possess or consume illegal substances or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
Because it's a warrant, probable cause has already been found in this case. I show that you're out on bond in case number 21 CF 2612AO, charged with sale or delivery of fentanyl. Counselor, I'm inclined to revoke that bond unless you can give me a reason not to.
Yes, Judge, that case has not been filed on. I would ask for you not to revoke that bond. That case is involving the exact same officers in this case. Very, very similar fact patterns, almost identical in nature. While I understand that the court is looking at a warrant case in the case before Your Honor today, the case that he is alibi on was not a warranted case. And
Counselor, I'm having a really hard time understanding you.
I'm sorry, Judge.
It's the connection is just bad. I'm asking everyone in the courtroom not to make any noise.
Okay, let me just try.
I heard the beginning of it.
If it's any better.
It is right now. Let's see.
Any better?
Yes.
Is it any better at this point?
Yes.
Okay. Judge, I'm just asking the court to take into consideration, while I know the case that's before you is a warranted case, the case that Mr. Thomas is alibi on, bonded out, forcing a judge, I would have argued no PC in that case. It's very similar in nature. I don't believe that the judge looking at would have found PC on that case. The state has not picked up charges on that case. It's been lingering for a good bit of time at that point. I don't believe the state will pick up charges on that case. Just
All
to be
right.
quite honest with the court.
All right, thank you, Counselor. At this time, I'll take no action on your out-on-bond case. Good luck, sir. Thank you,
Your
Counselor.
Honor. Thank you, Judge. Have a wonderful day.
You as well.
Thank you. Bye-bye.
Your Honor, also just for the record, that case came in as a sale and delivery of fentanyl, not a possession of fentanyl. I think it's wrong on the face sheet.
Okay. Please tell me your name.
Stephon Lee Watts, Jr.
In 21 CF 3168, you're here charged with possession of a controlled substance. I'll appoint the Public Defender's Office to represent you. There is probable cause. Your bond will be $1,000. You're not allowed to possess or consume illegal substances or have contact with any known drug dealers. Do you understand?
Yeah.
In case number 21 CF 3032, a warrant was issued for your arrest, charging you with robbery. The bond is $3,500. You're not allowed to return to that scene. You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to have any contact with the victim or any witnesses in the case. Do you understand?
Yes, ma'am.
I'll appoint the Public Defender's Office to represent you in that as well. As to his out-on-bond case, it's a battery. I'm inclined to revoke. Unless you can give me a reason not to, Counselor.
Please don't.
It's a battery charge for which he's out on bond, and he gets arrested for a robbery.
Yes, Your Honor.
So they're both violent.
In the court's discretion.
I'm sorry?
We'll leave it in your discretion, Your Honor.
All right. I'm going to revoke your bond at this time. Your attorney will have to file a motion in front of the trial judge. Good luck, sir.
Your Honor, Trowbridge, his behavior.
All right. It's 20 CF 8186. Counselor Acapius was issued for his arrest with no bond for failing to appear. I'm going to appoint your office to represent him.
We'll waive, Your Honor.
All right. And then in 21 CF 3186, possession of cocaine, indecent exposure, and possession of drug paraphernalia.
We'll waive, Your Honor.
All right. I'll appoint your office. There is probable cause. His bond is $1,000, $100, $100, and $100. He's not allowed to return to the scene, possess any illegal substances, or consume them, and he's not allowed to have contact with any known drug dealers.
Your Honor, I believe the indecent exposure was also, never mind, it's a different case, I'm sorry.
I did, it's none. Please tell me your name.
Brian Wynn.
In case number 21MM1868, you're charged with indecent exposure. I'll appoint the Public Defender's Office to represent you. There is probable cause. Your bond will be $500. You're not allowed to return to the scene or have any contact with any witnesses or the victim. Do you understand?
Yes, ma'am.
In case number 21 CF 3162, you're charged with possession of methamphetamine and fraudulent use of personal identification information. I'll appoint the Public Defender's Office to represent you. There is probable cause in this case. Your bond is $1,000 on count one, $150 on count two. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Do you understand?
Ma'am.
As to his out-on-bond case, it's a burglary of a structure. I'm revoking his bond at this time. Your attorney will have to file a motion in front of the trial judge. Good luck, sir. Those are all done. Please tell me your name.
Delia LeBoy.
You're here because a warrant was issued for your arrest in 2014 CF 11913 for violating your probation by changing your residence without first procuring the consent of your probation officer, leaving your county of residence, and failing to pay your court fines. There's no bond authorized on that warrant. I'll appoint the public defender's office to represent you. Do you want to enter a denial, Mr. George?
Yes, we're enter or deny.
It'll be set for a VOP date. We don't? All right. Good luck, ma'am.
Thank you.
Please tell me your name.
Josias Martinez.
In case number 21 CF 2662, a warrant was issued for your arrest for failing to report and re-register as a sexual offender. Your bond will be $10,000. You must maintain your reporting requirements. Do you understand?
Yes, ma'am.
Is there also a VOP?
Yes, Your Honor, they did an on-view VOP.
Is that 2007 CF 9771?
Yes, Your Honor.
All right. You also have a violation of probation with no bond at this time. I'll appoint the public defender's office to represent you in both cases. Good luck, sir.
Thank you.
Please tell me your name.
Luis Saldana, Your Honor.
In case number 19 CF 5369, a warrant was issued for your arrest for violating your probation by failing to live without violating any law, being charged with violation of a domestic violence injunction, and 2 counts, or 2 separate cases of that. There's no bond authorized on that warrant. I will appoint the public defender's office to represent you. Good luck. Please tell me your name.
Shepard.
Okay. In case number 21 MM1886, you're charged with trespass on property after warning. I'll appoint the public defender's office to represent you. There is probable cause in this case. Your bond will be $500. You're not allowed to return to 2200 Americana Boulevard. Do you understand?
I'm so sorry, Your Honor. This Stephon Shepard? What case was that?
I only have violations of probation for him.
Yeah, and
That has his name on it. I have a trespass case with his name on it.
okay, I'm sorry. You can resume, Your Honor.
In case number 20 CF 2907, you have a violation of probation with no bond. I'll appoint the public defender's office to represent you in that case.
I'm sorry, Your Honor. The reason why we did not have that is because he already bonded on that at 4:25 this morning. So he wouldn't need to be IA for that one.
Well,
I'm so sorry.
they gave it to the judge, so the judge read it.
Yes. Nobody told us, so
Mm.
we don't know that.
Sir, it looks like you are a violent felony offender of special concern. And it says there's a third case, which I don't have.
I believe it's the other violation of probation.
I don't have it. Does anyone else have it?
Yeah, I can print it out, Your Honor.
The 2181085.
I don't have it. I had 2 cases. 21-81085. It's another violation of probation. And there's also no bond authorized on that. I'll appoint the Public Defender's Office to represent you on that one as well. Good luck. Yes, sir. Can you get closer to the microphone?
Being that I already bonded out on the trespassing, right? Will I be appointed like a court date for the probation, for the violation of probation?
Yes, you have 2 violations of probation, and you'll get a date for both of those as well as for the trespass. But for the trespass, you're still in custody, so all of those court dates will be dealt with while you're in custody.
Will the time still be counted even though I bonded out? No?
Technically, no, but your attorney will ask the judge to do it, and
Right.
it'll be very compelling for the judge, I imagine.
Okay, do you know how far stretched will the court date be for the violation of probation?
I don't.
No? All right.
That's up to your attorney, the state, and the judge who's handling it.
All right, thank you.
Yes, sir, good luck. Please tell me your name.
Manuel Siaka.
In case number 2017 CF 12907, you're charged with violating your probation. There's no bond authorized. I will appoint the Public Defender's Office to represent you. It looks like he's also a violent felony offender of special concern. All right, so is there a second case here? Because I don't have that.
No, Your Honor. He was already seen on that.
All right, good luck, sir.
Your Honor, Clark, bonded.
All right. And what did we figure out about Delquan Charles?
We don't have him on our docket.
I don't have paperwork for him either, Your Honor.
You what?
I don't have paperwork for him either.
I don't know why I have it then. So I'm going to give that back to the clerk. All right, is there any other business before court adjourns for the day?
No, Your Honor.
No, Your Honor.
All right.
Just to be clear on the record, is Charles Lacan, you're not doing anything with it, right?
I don't know what to do with it.
I just want to make it clear since nobody knows.
I don't have it. I don't know what to do with that.
Yeah, I didn't know anything about that. That's why I was.
All right. Court's adjourned.